sentence you to life in confinement without parole.
That's f***ing horse shit. You do whatever the f*** you want.
Why are they shutting my mic off?
I'm the federal witness of the United States federal government. I demand some goddamn respect, you. All I did was trespass on property.
Ma'am, you gotta create the community that you want to live in.
Bond court is a free service, but it takes several hours of my time every day. Less than 10% of Bond court viewers hit the like button, and less than 1% leave a comment. If you want Bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
You are here for an initial appearance after detention. The rules of criminal procedure require that you be brought before a judicial officer within 24 hours of your arrest. The purpose of the initial appearance is to have a judge list the charges against you, inform you of certain rights that you have, and to determine the conditions of your release. You should have already received a copy of these charges. The judge will review your paperwork to determine if there was probable cause to arrest you. If the judge finds probable cause, he or she will then determine if you qualify for bond and what the monetary and non-monetary conditions of your bond should be. If the judge does not have enough information to make a probable cause determination for your arrest, the state may be given additional time to amend the paperwork. You should also be aware of the following rights afforded to you by the Constitution. You are not required to say anything at this proceeding. Anything you say can be used against you. You have the right to communicate with counsel, family, or friends, and if necessary, you will be provided a reasonable means to do so. You have the right to counsel. If you have not already retained counsel and cannot afford counsel, the judge will appoint you a public defender. For the purposes of today's initial appearance proceedings, you may be able to briefly speak with a public defender regardless of whether the public defender is appointed for you. In order to have an attorney appointed by the court to represent you, you must be financially eligible, as determined by the court based on financial information you provide. Therefore, if you have not already done so, please complete, to the best of your knowledge, the financial affidavits provided by the correction officers. An application fee for the services of appointed counsel will be assessed. If you do not speak English or Spanish, please let a corrections officer know. When the judge is ready, she or he will begin calling your case by name. Please listen carefully for your name. When called, please approach the microphone as directed by the corrections officers. Thank you.
Usted se encuentra aquí para una audiencia o vista preliminaria, después de haber sido arrestado. Las leyes y estatutos criminales del estado de la Florida requieren que se celebre una vista preliminaria ante un oficial judicial dentro de un plazo de 24 horas después de su arresto. El propósito de esta vista preliminaria es para que el juez pronuncie los cargos contra usted, para que se le comunique a usted sus derechos procesales y para determinar las condiciones de su libertad o fianza. Ya usted debería haber recibido una copia de estas alegaciones o acusaciones por escrito. Ahora, el juez revisará la documentación en su caso para determinar si existe motivo fundado o causa probable para su arresto y detención. Si el juez determina que existe causa probable o motivo fundado, entonces decidirá si usted califica para que se le otorgue una fianza, tanto como cuáles serían las condiciones monetarias o no monetarias de dicha fianza. Si el juez no posee suficiente información para determinar si existe causa probable o motivo fundado para justificar el arresto, se le concederá a la Fiscalía tiempo adicional para modificar la documentación. También se les avisa que posee los siguientes derechos que se les otorgan por la Constitución. A usted no se le puede obligar a decir nada durante esta vista. Cualquier cosa que diga podrá ser utilizada en su contra como evidencia. Usted tiene el derecho de comunicarse con un abogado, pariente o amigo. Y si es necesario, que se les proporcione los medios razonables y disponibles para hacerlo. Usted tiene el derecho a un abogado. Si todavía no ha encontrado o contratado un abogado y no tiene los recursos para hacerlos, entonces el juez le nombrará un defensor público. Para el propósito de la audiencia preliminaria de hoy, se le permitirá hablar brevemente con un abogado de la Oficina del Defensor Público, aun cuando no se le haya nombrado para representarle en todo el caso. Para poder recibir la designación de un abogado, primero debe calificar económicamente según lo determine el juez. Esto será basado en la información financiera que usted proporcione aquí. Por lo tanto, si no lo ha hecho todavía, de la mejor manera posible, por favor, llene el formulario de insolvencia económica que se le ha proporcionado por el oficial de correcciones. Se le impondrá un recargo o costo por los servicios del defensor público. Si usted no habla inglés, por favor, hágale saber al oficial de correcciones. Cuando esté listo, el juez comenzará el proceso llamando a cada una persona y caso por su nombre. Por favor, esté pendiente para pasar adelante cuando escuche su nombre y cuando escuche su nombre, haga el favor de acercarse al micrófono, tal como le indique el oficial de correcciones. Muchas gracias por su atención.
You are here for an initial appearance after detention. The rules of
Good afternoon, Osceola County. Can you hear me okay?
Can hear you, Judge.
Fantastic. Mr. Assistant Public Defender, your name for the record, please.
Alexander Rosa.
Thanks, Mr. Rosa. And for the state? Ms. Boudin. And pretrial release.
John Marino.
Thank you, Mr. Moreno. Mr. Rosa, any interpreter cases or move-ups requests?
Yes, can we get Sean Fleck first?
Yep.
I need an interpreter for Louis Cologne.
All right, thanks. State of Florida versus Sean Fleck. Hey, good afternoon, Mr. Fleck. Mr. Fleck, you and I have never met because I don't believe that you have ever agreed to come to court. We have some court hearings coming up. Madam Clerk, can we find out what Mr. Fleck's court date is?
His next court date is May 18th at 8:30.
All right, Mr. Fleck, we're going to see each other, and that is going to be next Wednesday.
I refuse.
All right, we'll see you next Wednesday, Mr. Fleck. Thank you. That'll conclude our hearing.
I refuse. I don't care about seeing you.
We get an interpreter on board for Mr. Cologne.
Good afternoon. This is Court Interpreter Claudia Villalba.
Good afternoon. We have Mr. Louis Cologne Falcone. The case number is 2008 CF 1507 and 22 CF 1383.
Okay, Your Honor, please allow me 1 second to connect to the headphones, please.
No, ma'am, this will be an initial appearance. Mr. Cologne Falcone is at the jail facility. You'll be doing the interpreting over the intercom system.
Okay, very well. Thank you.
Good afternoon, Mr. Cologne Falcone.
Buenas tardes, señor Colón Falcón. Good afternoon.
Sir, you are with us based on an allegation of a new law offense.
Señor, usted se encuentra aquí con nosotros porque hay una alegación de que se ha cometido un nuevo delito.
The new law offense case number is 2022 CF 1383.
Y el nuevo incumplimiento de la ley es el número de caso 22 CF 1383.
The allegation is failing to report an email address or an internet identity.
Y lo que se alega es que usted no reportó una dirección de correo electrónico o ubicación de correo electrónico de un perfil de correo electrónico.
There are 2 counts with that allegation.
Y son 2 los cargos que contienen esta alegación.
I find probable cause.
Hallo de que existe un motivo fundado.
I will appoint the Office of the Public Defender to represent your interests.
Le nombraré la oficina del defensor público para que ellos representen sus intereses.
Court will set bond in both counts in the amount of $2,500.
El juez le impondrá una fianza por ambos cargos en la suma de $2,500.
Fortunately, you are currently on probation in 2008 CF 1507.
Afortunadamente usted ya está en probatoria por el número de casos 08 CF 1507.
I find there is probable cause to believe you have violated probation in that case.
Y hallo de que existe un motivo fundado para creer de que usted incumplió con la probatoria que usted recibió por ese caso.
The court is going to find an on-view violation.
El juez determinará de que el incumplimiento de la probatoria fue algo que ocurrió en el sitio.
Bond will be set in the amount of none.
Y la fianza que se le fijará en estos momentos no se le fijará.
I will appoint the Office of the Public Defender on both cases.
Le nombraré la oficina del defensor público por ambos casos.
They can petition your trial judge to consider a bond once they give the court some more information.
Una vez que le den más información al tribunal, sus abogados podrán hacer una petición ante el juez que va a manejar este juicio con respecto a su fianza.
Thank you very much.
Muchas gracias. Have a good day. Your Honor, may the interpreter have your name, please?
My name is Keith Karsten.
Thank you very much.
Thank you, Madam Interpreter. Have a good day.
You too. Bye-bye.
Bye. Okay. Thanks, Ms. Boudin. I think the court reporters are asking that you get a little closer to the microphone. Thank you. All right, good afternoon. For everyone here for initial appearances, my name is Keith Karsten. I'm one of your circuit judges. As you learned from the little video that you've watched, initial appearances to make a determination as to whether there's probable cause for the arrest that's already happened. Second thing we'll talk about, as you've seen, is I will appoint a representative from the Office of the Public Defender if you qualify for the state-appointed attorney's efforts. And after that discussion, we are going to have a talk about bond conditions, if any, if you qualify for bond, that will get you back to your lives while these cases are pending. I understand that many of you may disagree with the allegations in your charging affidavit. I completely understand and get that. Today's not a day for that discussion. You should save that discussion for a discussion with your attorney and your trial judge, which is unlikely to be me. State of Florida versus Joshua Brannon.
He's in the hospital, Your Honor. Can I ask for a reset?
All right, thanks. We'll reset that to the weekend duty judge. State of Florida versus Reginald Mouche or Mouche. Good afternoon, sir. Pronounce your name for me.
Reginald Mouche. Good afternoon.
Good afternoon, Mr. Mouche. Mr. Mouche, you were arrested based on a warrant out of Orange County. The only information that I have is that it was an allegation of armed burglary of a conveyance. Your bond is currently set in the amount of none. You're going to remain on no bond until we can get you over in front of that judge. I will appoint the Office of the Public Defender since we're within the same circuit. So we'll let Orange County know you're here with us and they'll come get you.
Can you repeat that for me?
Yes, sir.
The
The charges? Sure. The warrant that I'm showing, and I don't have a whole lot of information for you, Mr. Mouche, but the warrant that I have indicates an allegation of a warrant. Case number is, not sure I have a case number for you. 2022 CF 5368. And the allegation is armed burglary of a conveyance. All right, thank you, sir. State of Florida versus Ginger Odom. Good afternoon, Ms. Odom.
Good afternoon.
Ms. Odom, you are here with us based on an allegation. The case number is 2020 CF 14804. Apparently that case was filed by Warrant. The warrant is out of Orange County. It contemplates no bond, so you're going to stay on no bond until we can get you over to Orange County. And I will appoint the Office of the Public Defender since we're in the same circuit while you're here with us.
That's a VOP, right?
I can't tell from the warrant. I would suspect, based on the no bond status, that it is an allegation of a violation of probation.
Yes, sir.
Okay. All right. Thanks.
Okay, thank you.
Yes, ma'am. State of Florida versus Becky Burnett.
Hello, Your Honor.
Ms. Burnett, good afternoon. Ms. Burnett, you are with us based on a warrant. The allegation is resisting an officer without violence. Judge Laurent has previously found probable cause for that allegation. She has set a bond in the amount of $500, and I will appoint the Office of the Public Defender to represent you. Your case number is 22MM1082. Thanks.
Do you know when my court date is?
I can ask. Yeah, it's going to be on demand, so I don't have any dates for you right now.
All right.
Thank you. State of Florida versus Cassie, Lynn Davis. Good afternoon, Ms. Davis.
How are you?
I'm well, thank you for asking. Ms. Davis, I issued a warrant for you. The allegations from your probation officer were that you violated your probation in 21 CF 1282. Based on the allegations in the violation affidavit, I issued no bond. You're going to remain on no bond. I will appoint the Office of the Public Defender. They can get you in front of me, and we can have a conversation about what's going on if a bond is being requested. Thanks.
Yes, sir. Thank you.
Yes, ma'am. State of Florida versus William Greene. Good afternoon, Mr. Greene.
Good afternoon.
Mr. Greene, you were arrested based on an allegation that you failed to appear for Judge Epperson. That would have been a failure to appear. Looks like a competency status. Judge Epperson has issued a bond in your case in the amount of $250. I will appoint the Office of the Public Defender if they weren't previously appointed on your case. Thank you, sir. State of Florida versus Jose Rodriguez Rivera. Good afternoon, Mr. Rodriguez Rivera.
Good afternoon, Your Honor.
Mr. Rodriguez Rivera, you were arrested based on an allegation that you violated your probation in 2021 CF 1026. The allegations were a new law offense alleged sometime in April, looks like April 18th. Based on that information in the charging affidavit, I did issue a warrant with no bond. You're going to remain on no bond until we can talk about it, and I will appoint the Office of the Public Defender to represent your interests. Thanks.
Thank you.
Your Honor,
Yes.
I approach.
Yeah, come on up. Yeah. You're right. Okay, let me address Mr. Brandon's case. Mr. Rosa, we're going to circle back to Joshua Brannon's case. Mr. Brannon was the victim in a vehicle versus pedestrian incident in which the Outstanding warrants were served on him while he was hospitalized. He is not in any capacity to attend initial appearances for the foreseeable future. In another case, the Office of the Public Defender waived his appearance and he was ROR'd. If you would consider waiving Mr. Brannon's appearance, I would appoint the Office of the Public Defender to represent him. This is an out-of-county warrant out of Orange County, and I would be inclined to release him on his own recognizance. Is that something that the Office of the Public Defender would be prepared to do?
Yes, Your Honor.
All right, thank you. Based on the information that I have on Mr. Brannon's case, we're going to accept a plea of not, well, no, I need to do that. This is an arraignment. I will find probable cause on the warrant. I will release him on his own recognizance as to the Orange County case in which the warrant is active. We've already done so on the Seminole County case in which the warrant was active. Thank you for that courtesy, Mr. Rosen. Thank you for reminding me, officer.
Yeah.
State of Florida versus Matthew Schilling. Good afternoon, Mr. Schilling. Hi. Mr. Schilling, you were arrested, and it has two case numbers. 21 CF 2653 has one allegation of fleeing or attempting to elude a law enforcement officer. That was determined by a warrant. Judge Bigney has already found probable cause for that allegation. Court is going to set bond in that case in the amount of $1,500. As to 21 MM 2552, Judge Bigney found probable cause for the following counts: trespass and resisting an officer without violence. Your bond in those cases in the amount of $500 as to count one and $100 as to count two. I will appoint the Office of the Public Defender to represent you on both your cases. Thanks. State of Florida versus Lucius Smith. Mr. Smith, good afternoon.
Good evening, Your Honor.
Mr. Smith, you were arrested based on an allegation that you failed to appear in front of me. That would have been back on November 29th, 2021. I didn't have any information based on your failure to appear. The court issued a warrant for you. That warrant has no bond. There was also a warrant issued in 22 CF 481. That is based on an arrest warrant that was signed by Judge Sanders Morency. That alleges a new count of grand theft. She granted you a bond on that case in the amount of $1,500. As to 21 CF 2221, you're going to remain on no bond until we can get together and have a conversation about it. And I will appoint the Office of the Public Defender on both of these cases. Thanks. State of Florida versus Benjamin Lee Walker. Good afternoon, Mr. Walker. You were arrested based on an allegation that you violated probation in 2018 CF 4293. That it's going to be in front of Judge Young. Judge Young was out. I signed off on the warrant based on the allegations in the affidavit. I issued no bond. Going to remain on no bond until you can get in front of Judge Young, let him know what's going on, and I will appoint the Office of the Public Defender to represent your interests. Thanks.
I have
Yes.
a private attorney, sir.
Okay, great. Who's that?
It's Mr. Arroyo out of Corey Cohen's office.
Okay, good deal. I'm going to withdraw then the appointment of the Office of the Public Defender. We'll let Mr. Arroyo know of today's initial appearance. And Madam Clerk, do we have any additional court dates?
Next court date is May 23rd at 8:45 a.m., courtroom 5F with Judge Young.
You're going to see Judge Young on May 23rd.
May 23rd?
Yep.
Sir.
Thanks.
What's that hearing for, sir?
I think it's probably a VOP status or arraignment. It's a VOP arraignment.
On the 23rd?
Mr. Arroyo may waive your appearance at that, but that'll be a conversation with him.
All right, thanks, sir.
Yes, sir. State of Florida versus Edgar Baez. Good afternoon, Mr. Baez. Mr. Baez, you were arrested based on an allegation of possessing cocaine and possessing drug paraphernalia. I took a look at the charging affidavit and do find probable cause for that allegation. I'll set bonds in your case in the amount of $1,000 as to count 1 and $500 as to count 2, with the special condition that you not possess or consume any illegal substances. I will appoint the Office of the Public Defender to represent you. Thanks. State of Florida versus Crystal Camacho Alvarado.
Your Honor, I'd also request the waiving of the reading of the charges in this case.
All right, thank you. Ms. Camacho Alvarado, I have read the charging affidavit. Mr. Rosa has indicated that you are aware as to what the allegations are against you. I do find probable cause for that allegation. I am going to set a bond in this case. Bond is going to be set in the amount of $500 plus pretrial release conditions. Those conditions are going to be that you have no contact with your family member, and that is Ms. Yanira Alvarado, and you're not going to be allowed to return to the Friar Oaks court address. I will appoint the Office of the Public Defender. Mr. Rosa, do you want to ask your client whether she needs to return for any personal belongings?
Yes, Your Honor, she would need a one-time return with law enforcement.
All right, I will order that you may return one time to that property with law enforcement to get some personal belongings while this case is getting sorted out. Thanks, Ms. Camano. Thank you.
Thank you.
State of Florida versus Scotty Coburn.
Your Honor, he's, I'd have to ask for a reset. He was in the courtroom earlier, but he had to be removed.
Okay. All right, we'll have him give it another shot with the on-duty judge tomorrow. State of Florida versus Arelis Crisostomo. Good afternoon, Ms. Crisostomo. Am I pronouncing your name correctly?
Crisostomo.
Crisostomo. Ma'am, you were arrested based on an allegation of petty theft, first offense. The case number is 22MM1085. I find probable cause. Your bond is set in the amount of $250, and I'll appoint the Office of the Public Defender.
Judge, she has a warrant out in Orange, and she's concerned about getting transported over there, but I'll let her ask the question to you.
Ms. Crisostomo, I'll help if I can. What are you asking?
Okay, so I already went to jail for the charges that I have the warrant for. I already
Out of Orange County?
I'm sorry?
Out of Orange County?
Yes, I already did 31 days in Orange County.
Okay, on what? Our case is here.
Okay, so I just want to know if there's any way that we can speed up the me being transferred to Orange County, because I have a kid, I have a life that I need to get back to.
I understand, and I bonded you out on this one. If you post bond, I don't know what. Do you have a warrant, a hold on you for Orange County?
Yes, I believe so. Yes.
Okay.
It does, Your Honor.
You can consider posting the bond, and then Osceola County will be more than happy to get you out of their jail. Send you over to
Okay,
Orange
so
County.
My bond can be posted like right now, so.
Okay. As soon as you bond out on our case, Osceola County has no reason to hold you, and I think they would happily get you over to Orange County or let Orange County know that you're there, and usually that happens in a couple days.
Okay.
Okay?
Thank you.
All right. State of Florida versus Angel Feliciano Ortiz. Good afternoon, Mr. Feliciano Ortiz.
Good afternoon, Your Honor.
You're with us based on an allegation of battery domestic violence related. The case number is 22MM1086. Based on the report, I do find probable cause for your initial arrest. I'm going to set a bond in your case in the amount of $500 plus pretrial release conditions. Those pretrial release conditions are that you're not to have any contact with Ms. Torres, and for the time being, you're not going to be able to go back to the Baybrook Drive address. I will appoint the Office of the Public Defender to represent you. Mr. Rosa, do you want to ask if he needs to return one time?
Yes, he does need to return.
Thanks. Mr. Feliciano, I'll let you return one time with law enforcement to get some personal belongings while this gets sorted out.
Thank you.
Thank you. State of Florida versus Mikel Harrell, or Harrell, excuse me. Pronounce your last name for me, sir.
Harrell.
Mr. Harrell, good afternoon. Mr. Harrell, you are with us based on an allegation of battery domestic violence related. I guess that had to do with something with your sister. The court finds probable cause for your arrest. I am going to set bond in your case in the amount of $1,000. For the time being, you're not to have any contact with Miss Carthen, and you're not going to get to go back to the Bernie court address while this is getting sorted out. I'll appoint the Office of the Public Defender to represent your interests. Mr. Rosa, do you want to talk to Mr. Harrell?
Yes, Your Honor, he would like a one-time return.
Yes, sir. You can go back one time, get some personal belongings while this gets sorted out, Mr. Harrell. Good luck.
Is that, excuse me, Your Honor, was that with law enforcement? I didn't hear you say
Yeah,
that.
I'm sorry. With law enforcement, you may return one time, so law enforcement will have to be present. They'll make sure nothing goes sideways, and you'll be able to get your personal belongings. Thanks. State of Florida versus Edwin Roller.
Good evening, Your Honor.
Good afternoon, Mr. Roller. Mr. Roller, you're in a similar circumstance as the last gentleman. Your case number is 22MM1088. The allegations are battery, domestic violence related. I have read the charging affidavit. I do find probable cause for your initial arrest. I'll appoint the Office of the Public Defender. The court is going to grant a bond in the amount of $500 plus pretrial release conditions. Officer, I understand that there was some contact with the alleged victim in this case?
Yes, Your Honor. The victim did state to my colleague that she would like contact and for him to return home.
Thank you, Mr. Moreno. Ms. Badan, do you have a history on Mr. Roller? Are there any?
He has no prior arrest history in or out of state.
I don't have any history other than what PTR has just provided, Your Honor. However, state would request that they maintain separate residence at this point. There was a child present, and based on how recent the events were.
Mr. Roller, I don't have a whole lot of information to make decisions with other than knowing that you don't have any previous criminal history. The court is going to allow no hostile contact with Ms. Soto Mateo. However, I am going to require for the time being that you maintain separate residences. So while you may be over there and you may even have contact in the home, you're not to spend overnight in the home until further order of the court. So you're going to have to find a place to be until you can get in front of the court and let them know what's going on. Your trial judge may amend that order upon the motion of your counsel. I will appoint the Office of the Public Defender to represent your interest. All that make sense?
Yes, that makes sense.
All right, thanks. State of Florida versus Francisco Santos, 22 MM 1089. Good afternoon, Mr. Santos. Mr. Santos, exactly like the two gentlemen before you, you are charged with one count, or sorry, you were arrested for one count of battery, domestic violence related. I have read the charging affidavit and I do find probable cause. Your case number is 22 MM 1089. The court will issue a bond in the amount of $500 plus pretrial release conditions. We don't have any information from Ms. Lanier, so at this point, you're going to have no contact with Ms. Lanier, and you're not going to be allowed to return to the... Give me just a sec. The address given looks like 700 Union Street. Not sure that that's a residence. I'll appoint the Office of the Public Defender to represent your interests, Mr. Santos. Mr. Rosley, do you want to ask whether that's a resident address and whether...
I did. It's not his residence.
Okay. So no personal belongings there?
No,
not so well.
All right. So, Mr. Santos, you're not allowed to have contact with Ms. Lanier, and you can't go back to that Union Street address until further order of the court.
That's where I was arrested. I don't go to visit her there. I mean, so why is there no permission to go back to somewhere I go to eat?
I don't know. There's a criminal offense that was committed there. I don't know what that place is.
That's where I had been arrested at. That's not where
Right. Tell you what, I know you want to give me some information. I've appointed Mr. Rosa, and you could, yeah. I don't know, Mr. Rosa, I don't know whether that's a business that he needs to go to, whether that's a public place. I have no idea.
No, it sounds to me like it's just a place that he goes to eat, so I don't think he needs to.
That's where I actually had a
Okay.
coming out of work. That wasn't where anything had like gone wrong or anything, so.
From what I'm understanding, it doesn't sound like he needs to return there.
Okay. Until this gets sorted out, don't go back to the 700 Union Street and don't have contact with Ms. Lanier. Thanks.
Yeah. So am I being pretrial released or?
You got a $500 bond plus pretrial release. Thanks. And State of Florida versus Sebastian Sustata?
Yes, Your Honor, and I would also request a waiving of the reading of the charges.
Thank you. Mr. Sustata, am I pronouncing your name correctly?
Yes.
Mr. Sustata, you are with us in 22 CF 1385. I will appoint the Office of the Public Defender at this time to represent your interests. Mr. Rosa tells me that you are aware of what the allegation in the charging affidavit alleges. I will find probable cause. I am going to set bonds in both of the counts. In count one, your bond will be set in the amount of $5,000. In count two, in the amount of $2,500 for a total bond amount of $7,500. Thank you.
Your Honor.
Yes, Ms.
State would
Boudin.
request bond conditions that he's not allowed to use anything with the internet and no contact with minors, Your Honor.
All right. I'm not going to prohibit use of the internet while he's perhaps trying to seek counsel, but I will order that Mr. Sustata have no contact with any minors. Mr. Rosa, do you want to have a conversation with Mr. Sustata as to whether he has any children?
Sure.
Thanks.
No children, Your Honor.
Okay. No contact with anyone under 18 except incidental contact through employment. Thank you.
Thank you.
Mr. Rosa, that's all the
That's everyone.
packets that I have. Any other clients?
Nope, I think that's everybody.
Have a good weekend.
You
Thanks.
too, Your Honor.
Officer, thank you for your help. Good to see you again, Ms. Boudin.
Same here, Judge.
Bond court is a free service, but it takes several hours of my time every day. Less than 10% of Bond court viewers hit the like button, and less than 1% leave a comment. If you want Bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
I would have checked my makeup if I didn't have a TV. Okay. Yeah, I'll just pass them off to you. Okay. We'll just do it that way. There you go. Right. All right, good morning. We are here for initial appearances. The first case will be Mark Anthony Maldonado.
Alicia Smith on behalf of the Public Defender's Office, Judge. And after we do Maldonado, the deputies asked if we can do Dixon next.
Sure. Mr. Maldonado, good morning. You have been, you're in custody on a violation of probation warrant. Your bond is presently at no bond. I believe you have is the public defender already appointed in this case?
No, Judge. He asked for the public defender, though.
All right. Do you want to have a public defender appointed, sir?
Yes, sir.
Can you hear me?
Yes, sir.
I can't hear him at all.
There you go. I'll cut it on. Say it now.
Yes, sir.
Okay. Then the court will appoint the public defender. Do we have a hearing date for him, or he'll be noticed? Okay. Anything else from the public defender or state?
No, Judge.
All right. Thank you. And what was the one you wanted me to call next again?
Dixon, Valerie Dixon.
Valerie Dixon. Okay. All right, Valerie Dixon. Trespass after warning. Good morning, Ms. Dixon. You've been charged with the crime of trespass after warning. I've examined the affidavit. I do find there's probable cause for detention. Your bond is set at $500. You do qualify for pretrial release. So the court will, let me pass the order along. There we go, getting it right. The court will grant pretrial release, and you will be given notice of future court dates and arraignment. Would you like the public defender to be appointed?
Oh, no.
I couldn't hear you.
No, sir.
No. All right.
Oh, no, yeah. Yeah, no.
She said no, Judge. It's just a delay.
Okay. That's all right. I got it. All right. Anything else from either party? No?
No, Judge.
All right. We'll conclude that case.
Your Honor?
Yes.
This is Margaret Jones with PTR.
Yes.
Can you hear me?
I do.
I was wondering, Ms. Dixon, if Ms. Dixon could have a mental health evaluation and maybe mental health conditions of PTR?
Does the public defender want to have any input on that?
No, I'm okay.
Judge, we just asked for straight PTR in this case.
Well,
without the mental health conditions.
Based on what I read, I think the mental health evaluation is probably a good thing. And whatever assistance it can give to her. So the court will order a mental health evaluation as part of the pretrial release. Thank you. Do I just pass this off to you? Okay. All right. Let's call Brian Michael Zushin. There's a number of matters.
Good morning.
Good morning. Just take me a moment here. There we go. All right. You are here on a number of matters. The first is charges of possession of marijuana under 20 grams and possession and use of drug paraphernalia. I do find probable cause for count 1, possession of marijuana under 20 grams. I do not find a probable cause for possession or use of drug paraphernalia. The arrest affidavit does not mention any items of paraphernalia that were found. The bond on count 1 is presently set at $500. You do qualify for pretrial release. We'll wait till we get to the end to determine that, but you will get, let me start over. You will be given PTR as to this case. All right. Okay. Huh? Oh, I'm doing this one? I did the possession of paraphernalia and cocaine first. Oh, I'm sorry, I didn't give them all to you. There you go.
Marijuana.
I had them all
cocaine,
separated
Judge.
out and didn't give them to you. Okay, so that's the... Got those in the right order? Okay. So PTR, PC's found, PTR on that one. And I don't think I signed
I
it.
thought you said no PC on count.
And no PC on
I'm sorry,
count
Judge, you
two.
said no PC on count 2.
That's correct. Yeah. And I need to sign it. I didn't sign those orders. Sign them later? Okay, all right. So that is that case. The next case is charge of driving under the influence of alcohol or drugs, first offense. I've examined the arrest affidavit. I do find probable cause on that case as well. The bond is set at $500. The court will put this case on PTR as well. And we'll address the public defender at the end of all of these cases. All right? You got that one? All right. The next case is resisting without violence. I have examined the arrest affidavit, and I do find probable cause for that charge. The bond was set at $500. The court sets release at PTR. Oh, there's one I got missed. That's this one. The next case is a charge of fleeing and eluding high speed with disregard of public safety and reckless driving. I've examined the arrest affidavit and I do find probable cause for those charges. The bonds are presently set at $500 and the court sets release at PTR. All right, the next one is fleeing and eluding high speed with disregard of public safety. The court has examined the arrest affidavit and finds probable cause. The court will set, the bond is presently set at 0. Court will set PTR as release for this case. The next case, the last case, is a charge of misdemeanor stalking. The court has examined the arrest affidavit and does find probable cause for that charge. The court will stay the bond at $1,000 on that case, and there will not be PTR. On that case, special condition in that case is that, sir, you are to have no contact of any kind with the victim in that case. I want to make very clear to you what that means. It means you do not contact her. It means you do not call her, text her. You do not reach out through social media. You do not try to attract her attention through social media. You do not have a friend reach out to her. You do not contact her in any way. And that also includes you should not come within 500 feet of her place of residence or 100 feet of her vehicle should you see her in a vehicle. Do you understand that, sir?
Yes, sir.
Okay.
Judge, I did want to make a probable cause argument as to the stalking charge.
Yes. Go ahead.
In the police report, there's no indication of any verification in terms of the multiple pages that the alleged victim indicated were made. The only incidents in terms of physical presence was when they were in the same location at which he left, well, which they both vacated. There's nothing in the police report to indicate that the police looked at either of the pages that she indicates that he made or that they were able to verify that he was the maker of those pages. So I didn't know that I didn't think there was probable causes to stalking since they were both in a mutual location, aside from the multiple pages they were supposedly made.
Well, I think what the court found was that the acts contained in this affidavit on that date, combined with the prior acts of creating the fake pages on social media and attempting to contact her, are multiple acts that would constitute stalking taken as a whole. That is probable cause there is that they would constitute stalking. Thank you, counsel.
Okay.
Now, sir, would you like to have the public defender appointed to represent you temporarily in these charges?
Yes.
Was that a yes?
Yes.
Okay. And the public defender will be appointed to represent the defendant in all these charges.
Thank you, Judge.
You're all caught up? Good? Okay. There's the next one. You know what? We'll sign them later, you said, right? Okay. The next case is Rafael Santiago Porcino.
He's in the hospital, Judge. Can we reset him for tomorrow?
Yes. So that'll be reset for tomorrow. Okay. Carmelo Jesus Rosario Huey.
He needs the interpreter, Judge. Do we have an interpreter?
Dalian Romero, Spanish interpreter, for the record.
Okay. Will you have a Spanish interpreter? Sir, you have been arrested on charges of dealing in stolen property, false verification of ownership information in a pawn transaction, and petty theft.
Señor, usted ha sido acusado de haber estado negociando con mercancía robada, haber provisto información falsa a una casa de empeño, hurto menor, como un primer delito también.
I've read the arrest affidavit and find probable cause as to all three charges.
Yo he leído la affidavit acusatoria y he hallado que hay causas que respaldan la acusación en los tres cargos.
Does the public defender or state attorney want to be heard on the conditions of release?
¿El fiscal o el defensor público quieren decir algo en cuanto a las condiciones de libertad?
Your Honor, may I ask PTR what the history is?
La fiscal está preguntando cuál es el
It
historial.
appears that he is on supervised state probation for case 2019 CF 706, petty theft 2 priors. That's what it says on the initial appearance information sheet.
Aparentemente está en libertad vigilada o probatoria por un caso y por otros 2 casos de hurto menor.
Your Honor, I also have some other criminal history, if you would like to hear that.
Yes, go ahead.
Okay. Since 2009, he's had 11 convictions, and that includes a battery, trespass, a cocaine charge, 4 larcenies, including the one that he's on state probation for, the petty theft with 2 priors.
Do we know if a violation of probation has been filed on the other case?
Se está comentando
No, we
que
do not
usted
know that yet.
tiene un historial desde el 2009 con 11 condenas, unos por casos de agresión, entrada ilegal, tenencia de cocaína, 4 por hurto menor, incluyendo los 2 por los cuales está en probatoria vigilada o libertad vigilada. Actualmente, el juez ha preguntado si ya se ha formulado una orden de arresto en el caso de incumplimiento de probatoria. Aparentemente no.
Sir, would you like the public defender appointed to represent you temporarily?
Señor, ¿usted quiere que se le designe el defensor público para que le represente temporariamente?
Lo que pasa es que yo no tengo. I don't have 11 charges.
Don't answer about that. Do you want the public defender's office appointed, yes or no?
Yes.
All right. Court will appoint the public defender temporarily. Does the public defender have any comments about the bond?
Se le designa el defensor
Yes, Judge,
público
I just-
temporariamente y el defensor público tiene comentarios que hacer en cuanto a la fianza.
I just asked the bond to be set. I believe per the warrant, the bond was set at $2,800 total, so I asked that bond be remained and no action as to any alleged or potential violation of probation. This is a warrant case, and I'm unable to verify if this would have predated the probation sentence or not.
All right. Then the
Estoy
court
pidiendo que se le
will
dé la-
stay the bond as established previously.
El juez va a determinar que la fianza es la misma que previamente se había predeterminado.
All right, thank you, sir.
Gracias, señor. Eso es todo.
So still with the same bond?
La misma fianza. Same bond.
All right, next case is Javier Rivera Pagan. Sir, would you please state your name?
Javier Rivera Pagán.
Sir, do you need the services of the interpreter?
¿Usted necesita los servicios del intérprete,
No.
señor?
No? Okay.
No.
You've been arrested on charges of possession of controlled substance without a prescription and possession or use of drug paraphernalia. The court has examined the arrest affidavit and does find probable cause for both charges. Your bonds were originally set at $2,500 and $500. You qualify for pretrial release, so the court will admit you to pretrial release. Anything further from the state or defense?
Nothing from the state.
This is
He
the
was
first time I've
deemed
done
not
IAs,
indigent,
folks,
Judge.
so I'm relying on all of you to let me know if I forget anything.
No, Judge, he was deemed not indigent by the clerk, so I don't believe he will be appointed.
Yes, I recall that. Thank you.
Your Honor?
Yes.
This is PTR. I
Yes.
would suggest that he have random drug screens.
Oh, excellent suggestion. So we'll add random drug screens to the PTR. All right, Mr. Daniel Ramdas. Sir, you've been arrested on a violation of probation community control warrant. That warrant indicates that your bond is no bond. Court will stay the bond as no bond until you see the judge who will hear your VOP. Would you like the public defender temporarily appointed to represent you?
Yes, sir.
All right, the court will appoint the public defender to represent the defendant. Oh, there's the order. I'm still working on this process here. There's that guy. All right, next case is Chad Perry. Please state your name, sir.
Chad Perry.
All right, Mr. Perry, you have been arrested on warrant for violation of probation out of Osceola County. Your bond is presently set at none. The no bond will be stayed until such time as you see the judge that issued the warrant for your arrest. Would you like a public defender appointed for you in the interim?
Yes, sir.
All right. Court will appoint a public defender temporarily to represent the defendant. There you go. Okay. Mr. Henri Josette, or Jose?
He bonded, Judge.
He bonded.
He
okay.
bonded.
All right, there you go. Victoria Rosina George. Would you please tell me your name?
Victoria George.
Hi, Ms. George. You were arrested on a warrant, a VOP warrant, out of Broward County, Florida. The warrant dictated that you should be held without bond and transported back to Broward County to face those charges. You will be held without bond pending resolution of this matter. Would you like the public defender appointed for any matter that may happen here in Orange County?
Yes.
All right, we'll appoint the public defender temporarily. Thank you. All right, the next case is Amanda Freeman. Would you please tell me your name?
Amanda Freeman.
All right, Ms. Freeman, you have been arrested on a charge of simple battery. I've examined the arrest affidavit, and I do find probable cause for that offense. Your bond is presently set. What is your present bond? None. You're being held without bond at the time. You qualify for PTR. The suggestion is bond with PTR. Someone please define that for me. So that's a monetary
Judge,
bond?
I'd ask for, yes, Judge, it's bond with the conditions of pretrial release. I'd ask for either straight PTR or a monetary bond, not both conditions, Judge.
All right. State want to be heard?
State would have no objection to straight PTR.
All right. Our PTR folks, you want to be heard on this?
Yes, Your Honor. She does not qualify for straight PTR. She only qualifies for a bond with PTR due to her prior history.
Right. Oh, I see. 7 prior battery arrests out of Georgia. So the court... Sorry?
I'm sorry, she also has an outstanding warrant in Georgia.
Oh, I
with
see
no
that.
extradition.
Okay. Well, the court will not put on PTR alone, but we will set a bond. Would the state or defense like to be heard on the amount of the bond?
Judge, I'd ask for a $500 bond in this case. Ms. Freeman is pregnant. She's actually scheduled to be induced this coming Monday. So she needs to be released. Well, we're asking for her to be released so she can go out and give birth in a safe environment due to being pregnant at this point. So we'd ask for a $500 bond in this case. In terms of additional release conditions, it's my understanding that the alleged victim, her brother, doesn't reside there. He was only there visiting. Pretrial release hasn't been able to make contact with him, but she resides there with her mother, so I would ask for her to be able to return home as well.
Does the state want to be heard?
Your Honor, based on her condition of being pregnant, the state has no objection to setting a monetary bond. I think the PD requested $500. Just even if they maintain separate residences, the state would request a no hostile contact order.
All right.
Such to be placed.
State, the court will set the bond at $500. The condition of bond will be that you have no hostile contact with the victim in this case. That means that you are not to get into any kind of argument with him. That means if he tries to start an argument with you, it is your obligation to leave. He will not get in trouble for getting in a fight with you, but you will. So if he tries to start trouble with you, you go the other way. If he comes to the house, you go sit in the bedroom by yourself. You understand that?
Yes, sir. Sir, is it able to, I could get a restraining order or something? I don't want no
That's not through
contact.
him. That's through the civil.
Yeah, we
That's
can't
civil.
do
That's
that. You'd have to file for that in the Osceola County Courthouse, but I can't do that today. All right?
Okay.
Thank you. Oh, yes. Would you like the public defender appointed temporarily to represent you?
That's fine. Yes, sir.
All right. Public defender will be appointed temporarily. Thank you. That's all. You can go have a seat. Okay, Michael Anthony Fabiani.
Good morning.
Please tell me your name, sir.
Michael Anthony Fabiani.
All right, Mr. Fabiani, you are charged with battery. I believe this is a domestic violence battery on your ex-wife. The court has examined the arrest affidavit. The court does find probable cause for that charge. You're presently being held at no bond. Would the state or defense, well, first of all, sir, would you like the court to appoint the public defender to represent you temporarily?
Yes, sir.
All right. The court will appoint the public defender to represent you temporarily. Does the state or defense want to be heard on the issue of bond?
Judge, I asked for straight pretrial release in this case. I'm sorry, state.
May we hear from PTR if there's any
Yes.
history?
Well, PTR, go ahead and tell us. I have your recommendation that he does qualify. But go ahead.
Yes, Your Honor. Yes, Your Honor. Prior to this case, in 1996, he had a burglary with assault, carry a concealed weapon, and trespass, and those were adjudication withheld. He had a 2-year probation for grand theft in 1992, and in 2008, a battery which was dropped. 2014, he had a sexual assault that was dropped and a violation of a domestic injunction that he did receive 1-year probation for.
So he has a prior conviction for violating a domestic violence injunction?
Yes, sir.
Okay. State, you want to be heard on this?
And PTR, he qualifies for PTR?
That's what it says, yeah.
Yes,
Your Honor,
ma'am.
Based on the history, the state would request a monetary bond to be set.
Yeah, the court will set a monetary bond based on the prior history. Does either side want to be heard on the amount of the bond?
I'd ask for a $500 bond, Judge, since he does qualify for PTR as a lower moderate.
Your Honor, again, based on the history, the state would request a $1,000 bond.
Yeah, I'm going to set the bond at $1,000. The conditions of release is that you are to have absolutely no contact with the victim in this case. That means you cannot call, you cannot write, you cannot text, you cannot email, you cannot communicate with her in any way. The only person who is permitted to communicate with her on your behalf is your attorney. You are not to have any other human being on earth contact her for any reason on your behalf. You're not to go back to the residence where she lives. You're not to be within 500 feet of it. You're not to be within 100 feet of any vehicle that she's in. Do you understand these conditions, sir?
Yes, sir.
All right. Without the ruling of the court. Okay, let me, you're right, I did put that down. A couple other conditions, sir, Mr. Fabiani, I also added, yeah, thank you, sir. I'm sorry, I'd forgotten about this. Were you living at the same residence?
My understanding, Judge, is that they live together and work together within the residence, so yes.
Okay.
We have a company, we all work together.
All right. So you're not to return to the residence. You're going to have to get a separate residence, and you may return to the residence one time with law enforcement to retrieve your personal items, any items essential for work. What kind of work do you do out of the house?
We do property appraisals and PI.
I'm sorry, what?
Property appraisals and PI.
Okay, well, you're going to have to do that from another location until this matter is resolved. Anything else from either counsel?
No, Judge.
Or
No,
from the
Judge.
clerk? Nope, we got it? All right, good to go. Thank you, sir. Okay, Ashley Ann Emmond. All right, ma'am, you have been arrested for a violation of probation. It was an on-site arrest based upon a failure to pass a drug test. You're presently being held at no bond, is that correct? Being held on no bond pending your appearance before the judge who is monitoring your probation. Does the other counsel want to be heard on the subject of bond?
If the court is inclined to grant a bond in this case, Judge, we'd ask for a $1,500 bond.
State?
The state would request that the bond stay at 0 until she is present before the judge handling her case.
The court will set a bond in this matter because this was a drug screen failure, not a separate new crime. So the court will set a $1,500 bond in the matter. Thank you.
Public defender appointed?
Oh, yes, I'm sorry. Ma'am, would you like the public defender appointed for you temporarily until you see the judge?
Yes, sir.
All right, the court will appoint the public defender. All right, next case is Richard Delgado George.
Good morning, Your Honor.
Good morning. What's your name, sir?
Ricardo Delgado George.
All right, sir, you have been arrested on a charge of battery. I do believe this is a domestic violence case. I've read the arrest affidavit. I do find probable cause. Would you like the public defender temporarily appointed to represent you?
You gonna hire private or you want a public defender?
I'm going to hire private.
He's gonna hire a private, Judge.
All right, and the court will not appoint the public defender at this time. The present bond is set at no bond. Would the state or the defendant like to address the issue of bond?
May we hear the history from PTR?
Yeah, PTR, could you give us a little background?
Yes, sir. In 2008, he had a possession of marijuana with intent, a battery domestic, possession of paraphernalia, flee and elude, and a careless driving. He also had a VOP. He served a prison term from selling marijuana in August of 2013. In 2014, he had a possession of marijuana paraphernalia conviction. He had 6 months probation. 2016, he had a possession of marijuana, destroying evidence, and passing counterfeit, and that was dropped. He also has he had conviction in Louisiana and Maryland. Maryland, he was placed on probation for that, and he's on federal probation right now. Expires January the 3rd, 2021 for illegal use of a credit card.
All right, sir, you want to tell me anything about your financial situation before I decide on the monetary bond?
I'll make the argument, Judge.
He didn't want you appointed.
For IA purposes.
Huh? No, I mean, he said,
Sir, I'm
sorry, just let me clarify one thing. Hold on. I thought he said he did not want the public defender. Or did I not ask
For
him?
initial appearance purpose. You did ask him, Judge. He said he was going to hire private for initial appearance purposes. I was going to appear on his behalf.
All right, sir, do you want the public defender to appear on your behalf for purposes of this hearing?
Yes, sir.
Okay, then go ahead, ma'am.
Judge, I asked that a bond be set in this case of no more than $1,500. While I understand pretrial release has read his history, there's no indication that there's been any on-view violation or that federal probation has been violated in any way. So I'd ask that he be giving a bond in this case of no more than $1,500.
State?
Yes, Your Honor, the state has no objection to setting a monetary bond, though the state would request that it be higher than that, considering his history, as well as the history that he has in other states. That's all.
Sir?
The probation with Maryland, that was basically supposed to be vacated off my record. Also, the domestic.
Sir, do you own any real property, like houses, land, anything like that?
No, sir. I have a vehicle in my name. That's it.
Okay, what kind of vehicle do you have?
An Audi,
What year?
2011.
All right. Do you have any bank accounts?
Yes, sir.
All right, where do you have bank accounts?
I'm employed too. I work.
Where
I
do you
have a
work?
bank account with Wells Fargo. I have a bank account with Wells Fargo. I work at the airport for Swissport. I'm contracted through Spirit Airlines, sir.
Okay. How much money do you have in the bank?
Probably about, I want to say at least $500, if anything. And I make payments on my credit card and stuff like that, sir.
Do you have any rich relatives?
I have family that, I mean, if needed to ask them for a lend of money, yes, that is possible, sir.
Okay, are these people that are local?
Yes, family members, you know.
How long have you lived in Osceola County?
I lived in Osceola County for, since 2008, sir.
Where'd you live before that?
I lived in Maryland
All right,
prior to that, sir.
go ahead. Prior to that, where'd you live?
I was born in New York, lived in Maryland, I live in Florida, sir. This is where I reside at. My kids live down here. All my kids, my two older kids go to the same school, which is not even 10 minutes away from my house, sir.
All right.
So,
Well, because the defendant is on, I guess, multiple probations, federal and state, if I heard that right.
no.
No, it's just one judge. It's
Just federal?
the federal.
All right. Because you're on federal probation and these events would violate that probation if you were convicted of them, I'm going to set the bond at $5,000. I want you to have a big stake in this game because we need to make sure you come back for court. So it's going to be $5,000. If you are released on that bond, you'll have absolutely no contact of any kind with the victim in this case. It means you're not to talk to her, not to text her, not to write her a note, not to ask your friends to talk to her. No one is allowed to talk to her on your behalf at all. The only person that can speak with her is if you get an attorney. If you hire an attorney, that attorney is allowed to speak with her. But aside from that, no one else can. You're not to return to the location where this occurred. Any other conditions that the state would like me to impose?
Maintain separate residences, Your Honor, if they don't
Maintain
already.
separate residences, that's correct. I think they already do, but don't remember. Yeah, maintain separate, anything else?
Judge, instead of the no return, can we just have the maintain separate residence? My understanding is that it's his mother's residence, so the alleged victim, doesn't actually live there, that she's in the process of moving. So we can have the maintain separate residence if she has in fact vacated.
Well, if she has vacated, he is not to go to her residence, wherever that is. If she vacates the mother's residence, then he can go back there. But he is not to go into any residence where she is. We'll make it even that broad.
Okay, so no contact
No
and maintain
contact.
separate residence.
He cannot enter any residence that she occupies, even temporarily. All right?
Okay.
Anything else from the state?
Nothing, Judge.
Anything from the defense?
No, Judge.
All right, then that'll
Thank you, Your
conclude
Honor.
this case. All right. I think this is our last one. Julian Lynn Bliss. Please state your name.
Julie Bliss.
All right, Ms. Bliss, you have been picked up on a warrant for violation of probation issued by the judge with jurisdiction over your case. The bond was set at none. That bond, no bond, will be continued. subject to your appearing before the trial judge. Would you like the public defender appointed in the interim?
Yes.
All right. Court will appoint the public defender temporarily to represent the defendant. Next, you'll be notified of your next hearing date before the court. Anything from the state or defense?
Nothing from the state.
No, Judge.
All right. Then that concludes all, I believe that concludes all of our Osceola County cases. Anybody
Yes,
care to
Judge.
dissent that? All right. Thank you very much, folks.
All right, see you tomorrow.
That was the one that bond. All right, so, these Spanish cases, right, interpreter cases. All right, so we have cases requiring the use of our interpreter. So we, I'm sorry, what? Oh, BCR? Okay. All right, so now we're over to BRC. Okay. Right. They bring him in here, right? They're coming live, they're not on video.
Yeah.
Okay. So the first case we're going to call, well, let's see who we have here. What's your name, sir?
Eric Texidor Rosario.
I don't think that microphone's working very well. I can't hear anything.
Eric Texidor Rosario.
Okay.
Texidor Rosario.
All right, there it is. All right. Mr. Rosario, you have been arrested on charges of possession of firearm by a convicted felon and possession of ammunition by a convicted felon. I'm sorry, these were warrants issued by a judge. The bond in those matters are set at $4,000 for possession of firearm by a convicted felon and $150 for possession of ammunition by a convicted felon. Those bonds will be stayed. Would you like the public defender appointed temporarily?
Yes.
Right, the court will appoint the public defender temporarily for purposes of representing the defendant. There you go. All right, anything else from the state or defense? All right, thank you, sir.
Thank you very much.
Please state your name, sir.
Felipe Aruo de Lima.
All right. Sir, you have been arrested on a out-of-county warrant for a charge of stalking. The warrant, the judge who issued the warrant indicated that you should be held on no bond pending your transfer to that county. Would you like the public defender appointed to represent you temporarily?
Yo tengo un abogado neste caso. Necesito, posso después que yo tengo uno.
I do have an attorney in this case.
You do?
Do I need one?
I believe not.
What county is the warrant from?
It's Osceola, it appears.
I'll look it up.
Yeah, it appears to be Osceola.
And Your Honor, for the record, I believe this defendant speaks Portuguese versus Spanish. I was able to understand him, but maybe for future paperwork, it needs to say that it's
Portuguese?
interpreter.
All right. So you'll be going to Osceola County to see the judge.
Ahora?
Now?
How's the process?
Well, I'm not taking you in my car.
Sorry, because it's my first time.
I understand. I don't know exactly.
I don't know nothing about this case. I'm not out to the country. I don't know what's happening.
I understand. I don't know what this transportation schedule is, but as soon as they can. 24 hours?
Okay.
What they said.
Okay.
Thank you, sir.
Gracias.
So we're not going to appoint the public defender at this time. Got an attorney down there. I thought we had one more. No? So Candido bonded? Okay. Have I reviewed these other ones? Oh, okay. I have reviewed this one. I did, yeah. All right, Mr. Barber.
Good morning, Your Honor.
Good morning. Sir, could you tell me your name?
Christopher Shazani.
All right. Sir, you have been arrested on a charge of battery, which is a domestic violence case. I've examined the arrest affidavit. I do find probable cause for the charge. Presently, you're being held on no bond. Would counsel like to be heard on the subject of bond?
Yes, Your Honor. He has no prior history at all. He's not a flight risk, Your Honor. He presents no danger to community. We'd ask that he be released on his own recognizance, or if the court's not going to do that, we would ask for a monetary bond of $500, maybe up towards of the maximum of $1,000. I know it came in as domestic violence. Based on the four corners of the arrest affidavit, it does state in there that they did not reside together, so it wouldn't actually properly be categorized as domestic violence, which we think would make it more appropriate for release on his own recognizance, Your Honor. Additionally, he was the sole occupant of that residence. The alleged victim does not reside there, so there are no issues about cohabitation, and so we just want to make sure he can go back to his own home.
All right. I did not get that impression from the arrest affidavit that they did not live together. Where is that?
If Your Honor looks on the first page, it goes 1, 2, 3. That fourth paragraph in the middle, the bigger one, the second line does state that they went back to his place, which indicates that it's
You're
not
right.
hers.
You're right. Okay. Thank you. Anything from the state?
Your Honor, just letting you know that the state has already started a process to transfer this to the governor's office, so any way Your Honor would like to handle this.
The governor's assignment. Yeah, I figured that was what was going to happen.
Yes.
All right. The court will, in this case, grant ROR. There is no prior history. The conditions of ROR are that you can have no contact of any kind with the victim in this case. No calls, no phone messages, no gifts, no cards, no reaching out through social media, no putting posts on social media to attract her attention, literally no contact of any kind. The only person that can contact her on your behalf is your attorney, Mr. Barber. Nobody else. Understand?
Yes, sir.
All right. All right.
Thank you very much, Your Honor. Have a great weekend.
You too. Thank you.
Does that mean all my battery DVs are getting ROR?
They have his background, yeah. Oh. It does look like it's a dating case, though, not a domestic case.
Yeah, I work in the DV division, and usually they come in as domestic, and then they transfer them out when they figure out it's not.
Yeah. Sure, let's do these. Yep, love it. Great idea. Okay, so we've got a few here that I have reviewed, so let's go ahead and call them. Joseph Murillo. I've also completed examining Stephen Polin, Carlos Torres Cardona, and Mandel Stewart. If anybody wants to have those, I don't know how you work back there, but if you have them in the bullpen. Just trap them between those two doors. It'll be perfect. In case you all wonder why I said that, I got trapped for 20 minutes between two doors in courtroom 3 when I was trying to find people. I had to call the comm center and have them call the corrections. Yeah. My card let me in.
But it didn't let you go through the next door?
But no, I got through both. Into the courtroom, and then as I was going back out, it stopped letting me. With my card. I came up the elevator that's right off the parking lot, and I was walking around the back, just looking. I looked in here, I looked in there. And, boy, I sure did. But it reassures me how secure this place is. Even judges can't get out.
Sorry, miss. Yeah, thanks.
All right. I'll do the rest of those in just a minute. All right, sir, please tell me your name.
My name is Joseph Murillo.
All right, Mr. Murillo, you have been arrested on a charge of domestic violence battery involving your daughter. I have found probable cause on that charge. Presently, you're being held on no bond. You don't qualify for the public defender, so you'll need to hire your own attorney. Does the state want to be heard on the subject of bond in this case? This is a father-daughter situation.
Yes, Your Honor. I also see that he's got no history in the state of Florida or elsewhere, so
All right.
the state has no position.
Sir, who are you?
May I say something, sir?
Yes, sir.
I have no criminal history.
You don't?
And I was in the Army in the past. I'm a vet. Honorably discharged.
It's my intention to release you on your recognizance.
Thank you.
But I just want to get an idea of sort of, generally in these circumstances, we try to separate the two people involved, but this is your daughter.
My daughter lives with her mother.
She lives with her mother.
Yes, we're separated. Her mother and I are separated. We're still married, but we're separated.
That's what I was going to ask you. So you're not the primary residential parent for your daughter?
Negative, sir. No.
Okay. Well, for the time being, part of your ROR is going to be that you not have any contact with your daughter until you get before the judge that's going to handle your case.
I understand.
And then we'll see what he wants to do, he or she wants to do about that. So ROR, only condition is no contact with the victim and maintain separate residences, which you already do.
Thank you.
All right, thank you, sir. Okay. Oh, those are all signed. Great. Oh, thank you. There you go. All right, sir, what is your name?
My name is Stephen Poland, sir.
Okay, Stephen Poland. Yes, sir. You have been arrested on 2 charges. One is burglary of a conveyance, and the other is grand theft. Let me just review this real quickly. Well, as to the burglary of a conveyance, I'm having some difficulty with the probable cause on that because it doesn't, the paragraph really doesn't tell me much of anything. Yeah, I mean, it doesn't say anything about how these cards were obtained, so I don't find PC on burglary of a conveyance. As to count 2, I don't find PC that it's grand theft because there's no indication of the value of the items stolen. Does the state want 24 hours to try and repair this?
Yes, please, Your Honor.
All right. All right, the state will, yes,
I was just gonna tell him what you were doing.
okay.
I would say,
So,
I'll object for the record, but.
of course.
Yeah.
What's happening here, sir, is that the information in your arrest affidavit is very, very sparse. It doesn't have enough information to establish probable cause that you committed the crimes charged. The law allows the court to give the state 24 hours to contact the police and ask them to supplement this affidavit, which, you know, it's one of the lazier affidavits I've ever seen. So we'll see you back here tomorrow. If the state does not supplement the affidavit with enough information, then I will find no probable cause and you'll be released on your own recognizance.
Thank you, sir.
Understand?
Yes, sir. Thank you.
Before you go, do you want the public defender appointed to represent you during this interim period?
Yes, yes, ma'am.
That's
Sir.
her. Well, it may not be her, but
Yes, sir.
it's this tall, bald guy with a big gray beard. He's
Thank you, sir. Thank you.
Come on, it's funny. Anyway, so we're going to appoint the public defender to represent you. We'll probably see you tomorrow.
You took my only PC challenge away from me.
Sorry?
You did my only PC challenge.
See, I was way ahead of you. Okay, next, sir, what is your name?
Mandel Stewart.
Okay. Okay, Mr. Stewart.
It's a refusal, Your Honor.
Torres refused.
I'm sorry, refuse what?
He's refused.
Torres Cardona. The one who's before.
Oh,
Mr. Stewart.
Torres Cardona has refused to come?
Yeah, so
Yes.
just reset him for tomorrow.
Okay, all right, we'll reset Mr. Torres Cardona for tomorrow. Mr. Stewart, you have been arrested on charges of burglary of conveyance, resisting officer without, 2 counts of resisting officer without violence as to 2 separate officers. I do find probable cause for all of those charges. At present, your bond is set at $3,500 on the burglary of a conveyance, $100 on resisting without violence on each count. Would you like the public defender appointed to represent you temporarily?
Yes, sir.
All right, then court will appoint the public defender to represent you temporarily. I see that you have you have signed the advice of rights. Very good. Would either counsel like to be heard on the subject of bond?
Your Honor, just based on the history that I have here, it includes similar charges, so the state would request that the bonds be stayed.
Anything?
Nothing from the defense.
Okay, so bonds will be stayed. Oh, wait, I'm sorry, there's 2, I apologize, there's 2 separate cases here, my mistake. The second case is you're charged with violation of probation, on 3 different charges: carrying concealed weapon by a convicted delinquent, possession of a firearm by a person found to have committed a delinquent act, and possession of burglary tools. Basically, what they're saying is that based on the allegations in the first case, those would be violations of your probation in the other case. Would you like the public defender appointed on that case as well? All right, we'll appoint the public defender on that case. The bond on these matters is no bond, and based on what I've read, I'm going to stay the bond at no bond until you see the judge on the VOP.
Is that juvenile probation or is that
Good point. No, it's felony probation.
Okay,
Yeah, it's 2015 CF 8560.
thank you.
All right? Good luck to you, sir. So that's those 2. I'm sorry? Oh, the move-ups. Okay. All right. Take a quick gander and... All right, let's bring in Victoria Kwane Smalls. Yeah, I'm just going to review them as they're bringing them in. Yeah, I'm usually pretty quick. See that in here?
This is Mr. Pullen. Why did-
I'm sorry?
They just brought me back, Your Honor.
Oh. Oh. Okay. Well, apparently you had a second case that I didn't realize, and if I have it here, I can, is it in this? It's not in this stack. I'm just going to read it real quick and see if we can get you done.
Is it the uttering the forged check? Is that what you're looking at?
Yeah, that's what I'm
Okay, I
about to
haven't
look
seen
at.
that affidavit. I thought that was part of the other one.
No. They got separated. He's on bond on that case? Okay, all right. All right, just a minute. Ah, okay, well, that fills in some of that. All right, so I've examined the arrest affidavit. In this case, you are charged with uttering a forged check. I do find probable cause for that offense, which is considerably more thorough than the last one. So I find probable cause for that. You are being held on $1,000 bond on that case. Would you like the public defender appointed for you temporarily?
Yes, sir.
All right, then we shall do that. Your bond at this point, unless either counsel would like to be heard about it, would be stayed at $1,000.
Nothing for this.
All right. All right, sir. And that concludes that. Is this something I have to do something with? Yes. Hold on a second. Okay, you're presently on bond on a possession of oxycodone case.
May I be heard on that?
You may.
Your Honor, it's been no information's been filed in that case. It's been over 33 days, so we would ask that you take no action because we would just file a 33-day motion and that he would be released on his own recognizance. So we ask that you don't revoke the bond.
State, would you want to be heard on that?
State has no objection to that.
All right, that's fine. We'll just take no action on that case at this time. All right, sir. Thank you.
Thank you, Your Honor.
You're all done. What was I looking at? Was this- Okay. All right. Would you please state your name, ma'am?
Victoria Smalls.
All right, Ms. Smalls, you have been arrested on charges of driving while license suspended, second offense, failure to register motor vehicle, and attaching a registration license plate not assigned. The court has examined the arrest affidavit. Does either counsel want to be heard on probable cause, since I just quickly read it?
No, Judge.
Okay. I do find probable cause. At present, your bonds are set at $500 on the first count and $100 on the second two counts. Does PTR have anything to, does she qualify, or?
She has not been interviewed, so at this point.
She has not been interviewed for PTR? All right. Anybody want to heard about the bond? All right, bond will be stayed at its present rate. Did I ask her about the public defender?
No,
Do you want to
is
have?
the public
Okay.
defender appointed? I know you have all the affidavits of insolvency.
Right. Do you, let's see, I don't have one on this.
You might not have one on this, but I know I don't have them like the Osceola PD does.
Okay. Well, at least temporarily, would you like the public defender appointed to represent you?
Yes.
All right, then the public defender will be appointed, the bond will be stayed as I indicated, and probable cause is found. Sorry? Hold on one second. You have another case? Oh, okay. All right. Sorry about that. You do have another case, and that is a charge of possession of controlled substance. I do recall having seen that in the arrest affidavit, the other one. So I do find probable cause to that as well. And on that case, your bond is set at $1,000. The court will appoint a public defender to represent you in that case as well. All right? Very well. Thank you for catching that.
Your Honor, she wants me to ask for you to reduce the $1,000 bond. She doesn't have any failure to appear according to the PTR face sheet. Looks like she has one adult misdemeanor conviction. There is juvenile history, but other than that, it looks like it's just one misdemeanor conviction.
What is the defense suggesting on that?
For the $1,000 bond reduced to $500 or $100 so that she can afford to take out on all these cases.
State?
State would have no objection to reducing.
That's fine. We'll reduce it to $100 on that one.
I appreciate it. Thank
The
you.
the other ones will stay the same, but that'll be
Thank you,
$100.
sir.
All right. Oh, on the possession case, we reduced the bond from $1,000 to $100. Taking a moment to read this. Oops. All right, I've read the arrest affidavit. I do find probable cause for the offenses of burglary of dwelling, grand theft, third degree, and criminal mischief. The bonds in these matters are set at $5,000 for the burglary of a dwelling, $150 for grand theft, and $100 for criminal mischief. Sir, would you like to have the public defender appointed to represent you temporarily?
Yes, sir.
Well, let's see if that's a temporary or permanent. Hold on a minute. All right, well, I do find that you qualify for the public defender, so I will appoint the public defender to represent you in this case during its pendency. Okay.
Your Honor, we would ask the $5,000 bond to be reduced to $1,000. He has indicated to me that he's having knuckle surgery next week, and he wants to be able to bond out so that he can get the surgery that he needs.
Okay. How'd you hurt your hand?
Upon coming
Got a little closer to the mic, can't quite hear.
upon coming to jail, I had got into an argument with the bouncer, and he slammed me on my arm.
Okay. PTR?
This is an add-on charge. He also has a warrant out of Volusia County.
Oh, out of what county?
Volusia.
Volusia County? So he'll, am I, you're not doing anything of IAs on that today? You know, I'm gonna not reduce the bond at this time, because if you've got a warrant out of Volusia County, if you bond out, they're just gonna take you down there.
No, my warrant has a bond on it. It was only like it was a mishap. I've been going through the same charge with Volusia County. Every single time that I get in trouble, they give me a warrant on behalf of that case, and I go ahead and pay the bond. But I never physically get a court date on behalf of that charge.
Is there
I've
a
been
bond?
fighting this charge since 2017.
Is there a bond on the Volusia County warrant?
A $1,000 bond.
So ideally, he would bond out on these charges. Volusia will come pick him up within 24 hours, then he'll bond out of Volusia County. That would.
State?
72.
Your Honor, the state would request that the bonds be stayed at the amount.
I think based on the seriousness of the charge, and if these charges are true, then you committed them while you were on probation for another case. I'm gonna leave the bond as it is, at $5,000. So the bond will be stayed. Okay. That must be him. All right, is this Mr. Woodson?
It is, Your Honor.
All right, give me just a moment. Does counsel want to be heard on the PC?
No, Your Honor.
Okay.
Unless you have a sua sponte PC challenge.
Well, I'm concerned about the intent to sell aspect. Does either side want to?
Yes, Your Honor. I will reach out to the officer.
Okay,
So I'm requesting a 24-hour reset for that.
I don't find a whole lot here that shows intent to sell, so I'll give the state 24 hours to supplement the probable cause on count one. I do find probable cause on, well, is there count two? No, there's only one, okay. Well, it says possession of cannabis there. Is there a separate affidavit?
I have possession of cocaine with intent to sell. I didn't see anything.
Okay, somebody just wrote on there. All right, so we'll see you back tomorrow on that case. The bond is presently set, sir, at $15,000. And that bond will remain in place until we see tomorrow what law enforcement comes up with. Okay? And did I ask him about your services?
I believe we're already appointed on his other case, but you have addressed as far as this case.
Would you like the public defender appointed to represent you, sir? Yes?
He said yes.
Okay. I can't hear him, but I can see him. You're good. Don't move. All right.
Okay. Your
The
Honor.
court will Yes.
Are you withholding action until tomorrow on the case he is out on bond on? That's where you saw the possession of cannabis.
Well, if you haven't found PC, you can't take any action on it today.
Well, I have found PC for possession of cocaine. I just asked the state if they want a time to supplement for the additional charge.
Okay.
So what's his charge that he's on bond on for now?
Possession of cocaine with intent to sell and possession of cannabis.
That must be what, I'm sorry. I do have that. That's what this is.
Yes.
Okay. Yeah, the court's going to revoke bond on the existing case, because my only question about PC was the intent.
Okay.
Yeah. So bond will be revoked on that case, and then tomorrow we'll address what the level of bond, if any, is on the main case. The new case, I should say. Okay. All right, why don't we take a break for a while, and I've got to review the rest of these. This isn't all of them, is there? Okay. So let's take a lunch break, and everybody can get something to eat, and I'm gonna look through these. It's more efficient than making you sit, watch me read. And then we'll be back in like 45 minutes.
Okay.
All right? And I'll take them with me as I go to McDonald's or wherever's close. Judge got to eat too, you know.
Yes.
All right, off the record. Story. First time I did IAs, they did them in what was the Municipal Justice Building, where they used to hold prisoners and OPD. They had a big courtroom in the bottom. You sit in there and all the defendants were out there just hanging out, you know?
Kind of like at Osceola, how they're all like sitting right there in the.
Yes, probably. I haven't been done in Osceola, but yeah. That was that building's gone now. It's been gone for years. Back in my day. All right, we're on the record. This is, sir, could you tell me your name?
Brennan McGarry, but they did my name wrong. They put McGrady.
No, I have McGarry.
Okay.
On the arrest affidavit, it says McGarry.
Okay.
Maybe it says it wrong someplace else. All right, so you have been picked up on a capias for failure to appear on a misdemeanor case. Your bond is set at $2,500, and if you bond out, if you don't bond out, you'll be set before the judge that issued the capias. I assume that, do you already have an attorney appointed in the case?
I want to pull a defender.
Let me double check and see if we're already on the case.
Okay, well, if you aren't, then you are now.
I don't think we were ever appointed, so.
All right.
Appointed now.
It says 2017 case. Wow. Okay, so public defender's appointed. Thank you, sir. Bond is $2,500. Next case is DeVell Williams.
I plead guilty to this charge. Okay?
I think
Sir?
he wants to resolve his case if it's
Yeah,
possible.
that's
but
fine.
hang on, let him talk and then we'll see.
All right, well, first of all, sir, what's your name?
My name is DeVille Williams.
Okay, and do you want me to appoint the public defender temporarily?
No, I don't need one.
Okay, so you want to plead guilty today?
That's right.
All right. Okay, would you, could we swear him in?
Yes?
Raise your right hand.
I
Please
had
swear to
a-
tell the truth, whole truth, and nothing but the truth, so help you God.
Yes, ma'am.
Okay. Sir, you're charged with trespass on
Trespassing after
property
warning.
after warning. Do you understand what the facts of this case are?
Yes.
Basically, the facts are that you went to a
Yes.
place, at 928 South Ivy Lane, where you were been previously told you weren't allowed to go,
That's right.
and you went anyway.
That's right.
All right, so you, do you believe you're guilty of this crime?
Yes, I'm guilty, okay?
Now, you have the right to have an attorney appointed.
Yes, I know.
Hold on. Let me get all the way through it. You have the right to have an attorney represent you in court, and if you cannot afford one, you have the right to have one appointed on your behalf. You understand that?
Yes.
And you want to waive that?
I know my constitutional right. I want to
Okay.
waive that.
Well, you got to let me go through them, because I've never taken a plea before, so this is going to be my
okay.
first time. So
Okay.
I've heard lots of them, but I've never taken one myself, so
Yeah.
give me a little time. You have a right to trial by jury. In other words, you have
That's
a right
right.
to have this heard by a jury of your
That's
peers.
right.
You waive that right.
That's right.
All right, and you realize that by pleading guilty, you waive any right to appeal your guilt in the case?
That's right.
Okay. Now, let's see, have I forgotten anything?
What do you say? My constitutional right.
Right.
I have, my Miranda rights.
Well, I'm not going to question you, so you don't have to waive those for a plea.
I think the only thing you left out, Judge, would be
And
immigration
Miranda
warning
right.
Oh, yeah,
or,
yeah,
yeah.
probation.
Good point. Yeah, if you're not a United States citizen,
I will be deported.
your conviction could result in deportation. That's correct. All right.
Okay.
I accept your plea of guilty. I find there's a factual basis for the crime. Would the state like to be heard on sentencing? It
No,
looks
Your Honor,
like
that's all right.
Mr. Williams, well, we don't have a whole lot here. Looks like he has, what's this say? Well, quite a few arrests, convictions, multiple trespasses, assaults, criminal damage, under $1,000, battery ×2, uttering forgeries, grand thefts ×2, disorderly intoxication. You're quite the Renaissance man.
Yes.
Yeah, a little bit
I
of everything
am.
in there.
I'm a God-sent man.
Nothing,
okay?
nothing, it doesn't look like, well, throwing a deadly missile, but
Yes.
nothing, nothing
There's
hugely
nothing to brag
violent.
about. There's nothing to talk about.
Yeah, you've been round and round. You've been to DOC twice,
Yes.
is that right?
I've been in prison 3 times for attempted murder.
Oh, well, that's,
Yes. I stabbed the guy 35 times. I tried to kill him.
have I ever prosecuted you?
No.
No? I'm
No.
surprised. That's pretty, what's it gonna take to keep you from going back to this place?
God.
God?
Yes, I did 25 years. I ain't been in prison in 25 years.
You had 25 years ago is when you were in prison?
Yes.
Okay. Well, what's it gonna keep you from going back to this place where they don't want you?
Some more Jesus.
Some more Jesus?
That's right. He's the Omni
No, seriously.
Omega, the Alpha and the Omega, the beginning and the end.
Okay,
And say God can't lie.
okay.
Okay. So
So
you have a
state-
blessed day. Okay.
Well, let me see what I'm gonna sentence you to, because
Okay.
I don't know yet. State?
Nothing from the state.
Oh, come on, you gotta help me in some way.
Well, based on the history that was listed here and volunteered, how many days does the defendant have? Or is just the one?
1 day.
He has 2 days per PTR,
Yes.
Oh, 2 days.
because he probably missed the cutoff for yesterday.
Yes.
Well,
So that means say I'm free to go home?
I don't think so, because I think you're gonna go back where you're not supposed to go.
No, I'm not.
Really?
No, really, I'm not going back.
I don't know, man, you keep going back there.
No, it's a lot of money there.
Well, but that's all the reason you're not supposed to go back
$1,000 a
there.
day. That's what I make $1,000 a day.
State, you got anything else you wanna say? As a friend of the court, would the public defender like to give any input?
I'd recommend credit time served.
State?
The state asks for 3 days, Your Honor.
3 days?
Well, let me do the 3 days, okay? I can eat it and get fat. Yeah, I'll do the 3 days, okay?
All right, well, we're gonna sentence you to 3 days with credit for 2 days' time served, and,
Yes.
maybe the Lord will come to you
Yes.
in the next day and tell you to stop going back to this poor man's place of business.
Okay. You have a blessed day, okay?
You too.
Judge, what are you gonna do with the court costs? You gonna,
Court
they only pay within a year,
all right, what are the court costs?
but 273.
Court costs of $273, pay them within a year,
Yes.
if you have the ability to pay.
I make $1,000 a day.
$1,000 a day?
Yes.
Well, then you should have no problem paying that tomorrow.
Yes, ma'am.
So we're costing you $1,000 every day we keep you in jail?
Yeah.
Okay, I'm gonna give you more time then.
You
All
have
right.
a next one, okay?
Take care.
Okay.
All right. Oh, that was Mr. Williams. Okay, so there's that one. All right, next case is Mr. Gervais. Please tell me your name.
Jethro Jervis.
All right. Mr. Jervis, you've been arrested on a violation of probation warrant from another county, Seminole County. The bond that's been set by the judge on that is no bond, so you'll be held on no bond, transported to Seminole County until you can see the judge over there. Any questions?
Wait, when is the transfer happen?
I don't know. What's that? Okay. They're in charge of that. I offered earlier today to drive a guy to Osceola County, but he didn't want me to. Okay. Next case is Montrevius Alston. Is that right? Is that you, sir? You need to answer out loud.
Yes, sir.
Okay. You have, this case was submitted and reviewed by Judge Carter, and she indicated that probable cause was not found. The state attorney is also given 24 hours to submit supplemental arrest affidavit. Has anything been submitted?
Yes, Your Honor, I have 2 copies here if Your Honor would like one.
Please do. I didn't see it in here, but it may not have been into the packet.
It was emailed to me late last
Okay. All right. Give me a moment. Has the public defender been sent a copy of this? You got it, okay. All right. Does either counsel want to be heard on the PC finding?
I just need one more moment, sorry.
Sure, no problem. All right. I do find, based on the supplemental affidavit, that probable cause exists as to the crimes charged. The bond is on count 1, which originally said at no bond. Does either counsel want to be heard on that issue?
Did they arrest him on the PBL or the first?
I believe it was a PBL, burglary of dwelling with assault or battery.
The state did not file their pretrial detention motion, so at this point, he's entitled to a bond on that count.
State?
Your Honor, based on the charge, the state would ask that the bond be stayed.
I believe this is a felony punishable by life, is it not?
Yes, Your Honor, based on the.
Was
Yes.
that's-
Sometimes I've seen it come in as a first, and sometimes I've seen it come in as a PBL, that's why I
it-
asked.
It's a PBL.
Right.
All right, the court will stay the bond at no bond. And Judge Barber can reconsider that.
We reserve the right for a full Arthur hearing downtown.
Of course. All right, thank you, sir. Next is Laney Cobb.
The other counts.
I'm sorry. Oh, the other counts, all the bonds are stayed.
At zero, the other counts aren't, he's entitled to a bond on the other counts.
No, he has bond on the other counts.
Oh, we've already addressed those, we only, okay.
Okay, well, at
Were those
least,
addressed yesterday? I'm just confused, because I have 5 counts
oh,
here.
that's okay. No problem. Yeah. Yeah, the bonds are set on the other counts.
Okay. Okay, I get it.
Yeah. I mean, I assume that's the original bonds, but I thought so. All right. Huh? Yeah, it's in there. All right. Please tell me your name.
Laney Cobb.
Okay. Mr. Cobb, you have been charged with the offenses of resisting an officer without violence, resisting a merchant, and grand theft third degree. Your bond on count 1 is $100. Your bond on count 2 is $100, and your bond on count 3 is $1,000. I do find probable cause exists based on the affidavit presented. Would you like the public defender appointed temporarily, at least?
Yes, sir.
All right. Actually, I believe we do have an indice affidavit, and he does qualify for the appointment of the public defender, so the court will appoint a public defender to represent you in this case. Well, apparently your bonds are $100 on each, I'm sorry, $100 on the first two, $1,000 on the last count. Let me see what we have here. Right. Anybody, anything else?
No, Your Honor.
All right, thank you, sir. All right, next is, looks like, yes, your name, ma'am.
Portia Urchill.
Okay. You have been charged with operating a motor vehicle without a valid license. I've examined the affidavit, arrest affidavit, and I do find probable cause. You're also charged with making a false report, knowingly given false information to law enforcement, 2 counts. I also find probable cause as to those. Your bond is, hold on. Your bond is presently set, let's see, where is that? Okay. Your bond on the no valid driver's license case is at $500. Your bond on the false report first count is $250, and the second count is $100, so the total bonds of all of them is $850. Would you like to have the public defender appointed to represent you?
Yes, sir.
All right. I don't have an affidavit, but I will appoint them to you temporarily until such time as you are arraigned on these charges. Either counsel want to say anything? I found probable cause on both.
No, Judge.
All right. Thank you very much. Okay, next case is Damon Jones. Tell us your name, sir.
Damien Jones.
I'm sorry, what was that?
It's Damien Jones.
Okay. Mr. Jones, you have been arrested on a charge of driving without a valid driver's license. I have examined the arrest affidavit, and I do find probable cause that you committed that offense. Your bond in that case is set at $500. You also are presently out on bond on, what's the case number? Oh, there it is. I'm sorry. Thank you. Okay, so you're on bond for 4 charges. in 2019 MM 2142, battery, resisting an officer without violence, 2 counts, trespass on school grounds, trespass on a facility, and simple trespass. In 2019 3227, you're on bond, on ROR, excuse me, for petty theft. And on 2019 MM 4095, you are had been issued a notice to appear for petty theft.
Your Honor, may I be heard?
You may.
As far as the battery, the resisting with trespass, that case, as far as I checked, has no information's been filed yet, and it's been more than, it's been 60 days since that he was arrested for that charge. In addition to that, this is a non-violent, non-serious criminal traffic infraction. I would ask that you take no action on the other cases.
State?
I did check on that last case, and it does look like nothing's been filed, though it has only been 60 days.
Have the other 2 cases been filed? The theft cases?
I'll double check.
The NTA is a charging document.
I'm sorry?
The NTA is a charging document, so I can't
Oh, right,
really
right.
make an argument in good faith on that one.
Yeah, the other
There
one
is
is,
filing.
looks like it's a arrest. I want to find out.
I do see filings for
Okay.
at least the first one.
All right. I'm going to revoke bond on the theft cases. That is 2019 MM 3227 and 4095. Obviously, the trial judges may decide to let you out. If they do, that's fine with the court. But for now, you're going to sit in jail until you talk to those lawyers.
PD appointed?
Yeah, would you like the PD appointed? All right, public defender will be appointed on the new charge. All right, thank you. All right. We have, could you please tell us your name, sir?
Edward Henry.
All right, sir, and you have been picked up on a violation of probation on charges of burglary of a dwelling, attempted burglary, and lewd and lascivious exhibition, 3 counts of that. The bond set by the court on that is none, so you will be held on no bond until such time as you see Judge Adams, I believe it was.
Public defender appointed?
Yeah, just going to get there. Would you like to have the public defender appointed to represent you in these matters?
Yes, sir.
All right, let me look at the, okay. It does look like you qualify, so the court will appoint the public defender to represent you in these matters, and you'll be in jail until you see the judge. Thank you. Okay. Oh, he does? Yeah. Okay, same, court's ruling is the same on both, his VOPs, so. Didn't realize there was 2, sorry. Okay, what's your name, sir?
Brian Smith.
Hi, Mr. Smith. You have been arrested on a violation of community control based on a warrant issued by Judge Young. The warrant holds you on no bond, so you will not have a bond until you see Judge Young. Would you like the public defender appointed to represent you?
Yes, sir.
All right, the public defender will be appointed to represent you in this matter, and they'll be notified of your next court date with Judge Young. Thank you. Okay, so that's all of those. All right. Let's see, that's that. This is this. Can you give me your name, sir?
Patrick Johns.
All right. Mr. Johns, you have been arrested on 2 charges. One is tampering with a witness to hinder communication with law enforcement. The other is battery, domestic violence. I've examined the arrest affidavit. I do find probable cause as to those 2 charges. Presently, you're being held on no bond. Would you like the public defender appointed to represent you? At least temporarily.
Yes.
I'm sorry?
Yes.
All right.
Yes.
Very good. The court will appoint the public defender to represent the defendant. Would counsel like to be heard on the subject of bond? You're being held
Yes.
on no bond at this time.
Yes, Your Honor. We would ask that you release him on his own recognizant, or he also qualifies for PTR. He has 0 criminal history, meaning he has no FTAs, and that's no criminal history out of state or in state.
This says he doesn't qualify for PTR.
Oh, my face sheet says yes. Something changed.
He does qualify. Oh, okay. Yeah, all right. Let me just, State, will you be heard on this?
I also thought that he did not qualify. The state was going to ask to set a monetary bond.
Okay. So, and sir, I do not want you to respond to this, but this appears, if I recall, this was stepmother and stepson, is that something like that? I didn't think it was like, let's see.
It's his stepmom.
Stepmom?
Yes.
Okay, that's what I thought. All right. I am going to grant the ROR since the defendant has no, wait, this says he doesn't, that's what, this is the mistake. He does qualify. Okay. Yeah, the court will release him on PTR. The condition, you will have no contact with the victim in this case. You will not return to the location where this occurred. And by no contact, I mean, thank you. There's a very thorough list here of what no contact means, but it means literally absolutely no contact with her. The only person that can contact the victim on your behalf is your attorney. I do find probable cause on both charges, and have done everything else we've done. All right, thank you, sir. Okay, Mr. Miller. You have been arrested on charges of battery by strangulation and domestic violence battery. I have looked at the arrest affidavit, and I find probable cause for both those charges. So would you like the public defender to be appointed to represent you?
Yes, sir.
All right, the public defender will be represented, will be appointed to represent you in this case. The present bond is no bond, and I note that you also are out on bond on 2019 MM 2708, which is resisting an officer without violence, that you are in PTR on dealing in stolen property, receiving money from a pawnbroker by false verification in 2018 3259, and you're on PTR on second-degree murder with a firearm?
He's already told me what he's going to say. He could be heard
Go ahead.
if the court will allow.
That case for the murder charge is I mean, I can't really say anything about that charge now, but I know that I have a paid lawyer for that charge. I go to court on the 6th of June, and besides that, I don't have no like FTAs. I just keep basically getting. I'm just lost right now. Like, I don't know.
Is that charge been filed? Is that information?
I'll double check now, Judge.
Yes, please do.
I'm sorry.
He wanted me to let you know that he's asking for you. He's asking that you do not revoke his bond in the cases he's out on bond on, because he says he's got 2 newborns at home, and he starts a new job on Tuesday that he will lose if his bond is revoked today.
Yes, Your Honor, there are files, charges filed in that case.
And that is an actual second-degree murder case, not attempt.
Second-degree murder with a firearm is what was charged.
Yeah. I'm going to revoke your bonds on all these charges. Second-degree murder is an extremely serious charge, and based on the facts that I'm reading, I'm not sure it's the greatest idea in the world for you to be in custodian to the children right now. So I'm going to revoke bond on each of those previously mentioned case numbers. The bond is revoked, subject to your appearance before the judge that's assigned to those cases. I will set a bond, however, on the DV case. Would counsel like to be heard?
Besides what's pending, he has little criminal history and no FTAs.
I do have a note here, I believe from PTR, that there is a prior DV offense with the same victim, so the state would also just ask for a reasonable monetary bond to be set.
Well, I'm going to set a monetary bond of $1,000 on count 1 and $500 on count 2. Obviously, with the no bond on the other ones, it's somewhat academic, but
Is the PD appointed on this case?
yes, PD is appointed. Oh, release conditions are no contact with the victim in that case, maintain a separate residence. Thank you. There you go. Oh, that's for you. Wait a minute. Okay, sir, could you tell me your name?
George Rufus Moore IV.
All right, Mr. Moore, you have been charged with the crimes of kidnapping as an act of domestic violence and domestic violence battery. I've examined the arrest affidavit, and I do find probable cause on those charges. Would you like to have the public defender appointed to represent you?
Yes.
Sorry?
Yes.
All right. And the public defender will be appointed to represent you in this matter. You're presently being held on no bond. Would counsel like to be heard on that issue?
Yes, Your Honor, the state has not filed a pretrial detention motion, so at this time, he's entitled to a bond, unless the court's defined through that consumption rate, which is the highest legal standard in the system, higher than beyond a reasonable doubt.
Is kidnapping, and I should know this, kidnapping a PBL or a F1?
I thought it,
I know armed kidnapping is a life offense, but is kidnapping a life offense?
I was under the impression it was a PBL. Is that what the?
I thought so too. I need to pull the statute, but I thought it was a PBL.
Yeah, let's look at that and make sure
Yes, Your Honor, what I have here is that it is an F1 PBL.
Okay.
So the state would ask that no bond be stayed.
Okay. I'm going to stay this at no bond on count 1. On count 2, I'm going to set a bond of $1,500 with a condition of no contact with the victim in this case. No going to a residence, no communicating with her in any way. And also, I'm going to add a condition that you have no contact with, what's the name of the guy you were with? George Arroyo, who is a witness in the matter. I believe George Arroyo is the witness. Yeah. All right, thank you.
Public defender appointed.
Public defender's appointed.
We reserve our right for a full art hearing downtown.
That's part of it. All right, sir. What is your name, sir?
James Glenn Owens.
All right, Mr. Owens, you have been arrested on charges of burglary of a dwelling with an assault or battery therein, and attempted sexual battery with deadly weapon or with force. I've examined the arrest affidavit, and I do find probable cause on both those charges. Would you like to have the public defender appointed to represent you?
Yes, Your Honor.
All right, let's see, do we have a, I don't have an affidavit of insolvency. Well, I don't have an affidavit from you right now,
The
but,
court could take testimony. Would the court take testimony?
sure. Go ahead, counsel, you want to inquire?
Sure, normally the judge does. I would say, how much do you make, how much money do you make? Do you have a job?
As far as I know, I was currently employed at the 3 and 1, but being in here, I'm not sure. If I'm left in here so long, I probably won't have a job. That's what I'm saying.
Okay, were you paid on a monthly basis, or?
I was paid every 2 weeks on Tuesday.
How much did you make approximately?
I was bringing in about my checks was anywhere from $600 to $700.
Every 2 weeks?
Yeah.
Do you have any dependents?
No.
No children?
No, not currently. I was helping Alexandra, with her child, but now that we're obviously having some kind of problem.
Do you have any bank accounts?
We were sharing one, but that was it.
Do you have any stocks, bonds,
No, sir.
expensive jewelry,
No, sir, not.
real estate? All right,
No,
public
sir.
defender will be appointed to represent you. Your present bond is no bond. Does counsel want to be heard on that issue?
Yes, Your Honor, the state hasn't filed a pretrial detention motion. Additionally, I don't think proof evidence promotion rate is here because it's not clear that whether he lived here or not from the arrest affidavit. It goes back and forth. They say that he did live here or he didn't live here. They go back and forth. Like some people say he was living here because in the beginning of the affidavit it says that he was a roommate, and that so he can't possibly burglarize his own place. And then at another point, they said he wasn't living there, so it's not clear. And given that proof evidence presumption great is a higher standard than beyond reasonable doubt, I'd say that there's reasonable doubt as to whether this was actually a burglary with battery. So I'd be challenging the burglary part, meaning it's not a punishable by life.
Can you point me to where it references him as being one of the roommates?
It's near the beginning, if I remember correctly. Just give me a moment to pull up the affidavit.
Sure.
But I do remember it reading where someone said that, where the independent witness said that he was a roommate. It was near the beginning when they were interviewing
Okay.
the independent witness.
The only thing I hear is it says, it references the witness saying,
Irving recognized the male as James and knows that he is her roommate.
Yes.
It's in the third, or not the third, it's in the fourth paragraph, the larger one.
no, I think what it says is, he knows that he is her roommate, Alexandra Novkov's ex-boyfriend.
Yeah, that's him.
Right, that's what I'm saying. In other words, he's not the roommate, Alexandra's the roommate, and he's the ex-boyfriend. See, that's how I stumbled with that a little bit at first, too.
I mean, it said, I guess, so my argument would be, like, whichever way you take it is ambiguous, and meaning that that proof evidence can't be great, because there's so much ambiguity in here.
Well, I think it's poorly written, but I think when you read the sentence as a whole, it's clear to me that she is the roommate's boyfriend rather than the roommate, because then that doesn't leave anything for Alexandra to be. So I am going to find at this point that proof is evident presumption great on the burglary of a dwelling with an assault or battery therein. So I will maintain the no bond status on that. I don't know that attempted sexual battery isn't a life felony anyway. If it was, I would not find proof is evident presumption grade on that. So we will need to set a bond on count 2. Any comments or thoughts on that?
He asked for a reasonable monetary bond. According to his face sheet, he has 0 felony convictions, 0 misdemeanor convictions, and 0 FTAs in Florida. I don't know if there's, it looks like there's some minor out-of-state convictions.
Right. All right, the court will set a $1,000 bond on count 2, but maintain no bond on count 1. And I believe I did appoint a public defender. Yes, I did. Okay.
Yeah.
This is the warrant. All right, sir, please tell us your name.
John Petidor.
All right, sir, you were arrested on a warrant in which Judge Tom Young found probable cause. It has 3 counts. The first is aggravated battery on a pregnant female as an act of dating violence. Second is false imprisonment. The third is tampering with a victim to hinder communication. Your bond on count 1 of the warrant is no bond. Your bond on count 3 is $3,000, and your bond on count, your bond on count 2 is $3,000. Your bond on count 3 is $1,000. Would you like to have the public defender appointed to represent you?
Yes, sir.
All right, let me look at the paperwork. Appears that you qualify for the public defender, so the public defender will be appointed to represent you.
Is it the warrant? There's nothing to do with each other.
Public defender would like to be heard on the subject of bond?
No, Your Honor, it's a warrant. We can't, I can't
Oh,
make
of
that
course,
argument
it's
in
a
good
warrant,
form.
yes.
In good faith.
Absolutely right. All right, well, that makes it easy. Okay. Okay, could you please tell us your name?
Starlisa Bargainer.
All right, you have been arrested on a charge of domestic battery, domestic violence. I have examined the arrest affidavit, and I do find probable cause in the case. Would you like to have the public defender appointed to represent you?
Yes.
All right. I have your financial affidavit in front of me. It appears that you qualify, and the public defender will be appointed to represent you. Your bond at present is none. Counsel, would you like to be heard?
Yes, Your Honor. She has no convictions. Although there are some arrests, she has 0 convictions and no failures to appear. PTR has indicated on the face sheet that she qualifies for PTR. We would ask that she be released on her own recognizance, given that she has no convictions, or in the alternative, straight PTR.
State?
State has no objection to PTR with appropriate conditions.
All right. The court will grant PTR. Conditions being that you have no contact with the victim in this case, Mr. Morris. Let's see. Since you were living together at the time, you will need to, yes.
Yeah, I'd like to be heard on the conditions. She indicates to me that that she has 2 children living there, and or 3 children living there. They are her kids, not his. It is her primary residence, so I would ask that there wouldn't be a do not return, but a maintain separate residences for the sake of the kids.
Sure, sure. What does that do if he doesn't want to leave?
If it's her house, she can file an eviction proceeding. That's generally
Okay. All right. That's what we'll do. So you have to maintain separate residence from him. You're not to have any contact with him as well. You can't call him, no messages, nothing like that. But you have to maintain separate residences. So that means what she said, which is if he won't leave, you got to take your kids and find someplace else to live. unless you're a victim. Okay? All right? Okay, anything else on that?
No, Your Honor.
All right. Thank you. Oh, that's what I just did. All right, sir, can you please tell me your name?
Jacob Connor.
All right, Mr. Connor, you have been arrested on a charge of domestic violence battery. This involves, I guess, your brother. I have examined the arrest affidavit. I do find probable cause. Would you like to have the public defender appointed to represent you?
Yes, sir.
All right. I've looked at the affidavit, and you do appear to qualify, so the public defender will be appointed. You're presently being held on no bond on this case. Counsel like to be heard?
Yes, Your Honor. Mr. Connor had 0 criminal history, not even as much as an arrest in Florida or out of state. So we'd ask he be released on his own recognizance, just like some of the other DV battery cases today.
That was dating, but no. He does not qualify for PTR?
It says yes on my face sheet.
Oh, mine says no, but these haven't been. He does?
He does.
Okay. Let's see. Did they live together? Hold on.
He indicates to me that he has other places to go.
Okay. All right. Then I'm going to release you ROR, and just, you have to have separate residences from your brother. Okay? I don't think PTR is really necessary. Okay. All right, would you please tell us your name?
Danielle Dunlap.
Okay, you are presently charged with 2 offenses. One is battery, dating violence. The other is criminal mischief, under $200. I've examined the arrest affidavit, and I do find probable cause for both of those offenses. So would you like to have the public defender appointed to represent you?
Yes.
All right. You do appear to qualify, so I will appoint the public defender to represent you. You're presently being held on no bond. Counsel like to be heard on the subject of bond.
Yes, Your Honor. Ms. Dunlap only has 1 misdemeanor conviction, which is driving on a suspended license. She does have other arrests, but it doesn't appear that there are convictions for those. So we would ask for her to be released on her own recognizance or a low bond of $500.
State?
State would note that, well, she didn't qualify for PTR because it looks like she's out on bond in another county. So the state would ask for a reasonable monetary bond to be set higher than what was requested.
How much are you suggesting?
The state would request 1,000.
Okay. All right. From what I understand, the defendant was in the process of moving out of the joint residence. Okay. I'm going to go ahead and set the $500 bond. She may have enough trouble with the other case if she's on bond on that case. The condition is you must maintain a separate residence from the victim in this case, and that you're to have no contact with him. Anything else, counsel?
No, Your Honor.
All right. Oh, count 2, thank you. Count 2 will be ROR. All right. Sir, would you please tell me your name?
Khalid Jones.
Mr. Jones, you are presently charged with the crime of battery, domestic violence. I have examined the arrest affidavit, and I find probable cause for you to be held on that charge. Would you like to have the public defender appointed to represent you?
Yes, sir.
All right. Let me just ask a couple questions. I don't have an affidavit here. How much money you make?
I don't got a job, sir.
I'm sorry, what?
I don't have a job, sir.
Okay. Before you got arrested, did you have one?
Like yesterday?
Yeah, yesterday or
No,
in the last
no.
few months?
No.
Well, when you do work, what do you do?
What you mean, like when I get a job?
Yeah.
What?
Have you had a job?
Oh yeah, I used to work at Universal Studios.
Okay.
Yes.
What'd you do?
Gameskeeper.
A gameskeeper?
Yes, that's
like
the
with the
like-
animals?
No, like you play the games, like
Oh,
in Simpson area.
The guy.
Yeah.
Okay. Yeah.
Yeah.
How much were you making when you were working?
We get paid every week, so like $500-600.
A week?
Yeah.
Okay. But how long it's been since you worked there?
Like a year. like a
Okay.
year.
You got any bank? You got a bank account?
Yeah.
You got any money in it?
To be honest, $100.
$100?
Yeah.
You got any expensive jewelry? Any
Nah.
expensive jewelry?
No.
You got a car?
No, sir.
Okay. You got real estate?
No, sir.
You own any hotels?
No, sir. No, sir.
You could be a Trump. I mean, I don't know. All right. I'll appoint the public defender to represent you.
Thank you, sir.
In this matter. All right. Your present bond is no bond. Counsel, would you like to be heard on the subject of bond?
Yes, sir. We just ask that you set a reasonable monetary bond. He doesn't qualify for pretrial release, but that's what I would ask for if he did.
Counsel?
State has no objection to setting monetary.
All right. What would you deem a reasonable bond?
$500?
Yeah, state will, the court will set a $500 bond in this matter. Condition of that bond is you are to maintain a separate residence from the victim in this case, and you're to have absolutely no contact with her of any kind, not only through you, but through any third party. The only person that can contact you on her behalf, contact her on your behalf, is your attorney. You understand?
Yes, sir.
All right. Thank you. Have a good day. You too. Okay. Would you please tell me your name?
Sharonda LaWine Levi.
All right. You have been arrested on charge of domestic violence battery. I have looked at the charging affidavit. I do find probable cause. Would you like to have the public defender appointed to represent you?
Yes.
All right. I have examined your affidavit, and you do appear to qualify, so the public defender will be appointed. At present, your bond is set at no bond. Counsel would like to be heard?
I believe the victim's here, so I'd rather let the victim testify, and then
Certainly.
I'll go from there.
Can we, do I do anything magical so we can hear him? No. Okay.
Hello.
There you go.
All right. I'm the victim. I'm the father of her child, and okay. She got locked up yesterday. The dispute was nothing but minor. Me and her does not have a problem, but this is the mother of my child. She helps me take care of my daughter, and I understand. I respect your decision, Honor. You know, you make the last final call, but I need her out here with me. I mean, she helps me. We got into an argument. Told the officers that, and they didn't want to hear that. They said somebody has to go to jail, and they picked her. I don't wish to testify. I know I'm not pressing any charges. I mean, I just ask that, can you honor my decision today, sir?
Sure.
Your Honor, may I inquire?
Yes, you may.
Sir, are you afraid of Miss Levi?
No, ma'am.
Do you want Miss Levi to come back home?
Yes, ma'am.
I have nothing further.
All right. I'm going to ROR the defendant. The condition of the ROR is that you will not have any hostile contact with him. So that means if he starts a fight with you, you got to leave, okay? Because he can start a fight with you, but if you fight back, you violated the order, okay? And I hope that you understand that you won't start any fights,
No, sir.
but you got to understand that you're the only one that's under this order, not him. Okay? So if it starts getting hot, walk away.
Okay.
All right?
Yes.
Okay. I noticed there is a another case that she's out on bond for.
May I be heard?
Yes, you may. I was
No
just
information's
going to
been
announce it for the record what it was.
Okay.
2019 MM 4284.
No information's been filed in that case yet, so we just ask that you take no action.
I wasn't going to anyway, but I
Okay.
just going to make sure it didn't look like I missed it. All right, thank you. Okay. All right, ma'am, what's your name?
Shaylanisha Mahone.
All right. I like your hair color.
Thank you. It's
Unique.
a little faded,
I like
but
it.
thank you.
I'm not trying for it.
It might look nice on you.
Well, you know, I worked a long time to get this.
Yeah?
Yeah, you know.
I like.
61 years and 7 children. That's what it takes to get this hair.
7, huh? I'm not far behind you.
Oh, don't tell me that. All right, you are here on a charge of domestic violence battery. I've read the arrest affidavit and I find probable cause. Would you like to have the public defender appointed to represent you?
Yes.
Yes?
I'm sorry, what was the question?
Would you like to have the public defender appointed to represent you?
Yes, sir.
Okay. The public defender is a real tall, older, bald guy, but this is the lady that's going to be helping you.
Thank you.
We could ask Mr. Wesley to come down.
I'm sure has nothing better to do this weekend.
There is no such thing as anything better. Anyway, so she'll be appointed to represent you in this matter. Presently, you're being held on no bond. Would counsel like to be heard?
Yes, Your Honor. We'd ask that you set a reasonable bond. The only reason she doesn't qualify for PTR is because she's homeless.
Because what?
Because she's homeless. PTR requires an address.
Right.
I know that you can order PTR anyway, and because my judge does it downtown all the time, and they can monitor her on pretrial release if the court orders her to.
Do you have a place to go when you get out?
I'm getting a hotel room.
Okay. All right. Can you afford to keep that going?
Yes, I work. I have a caseworker, and we're working
Good.
with rapid rehousing to get me into housing and everything.
Okay.
I'm just in a little layover right now.
Sure.
Getting the paperwork done.
All right. You don't, do you have any reason to have anything to do with the victim in this case, Mr. Johnson?
Wait, what is the question?
Do you have any reason to have anything to do with Mr. Johnson, the victim?
They share children.
Huh?
They share children.
They share children. Okay. Well, I'm gonna release you. On PTR. She says they do it all.
They do downtown. They release them on PTR even if they don't have an address or if they don't qualify because PTR has been working with them recently.
Tell me, what's the effective difference if I release her on PTR versus ROR?
If she's released on PTR as a transient, she's going to have to be next day reporting, so she's going to have to report on Tuesday, and there's a fee of $17 that you'll have to pay for the program.
Yes, $17.
So that's not the only reason why she didn't qualify for pretrial.
If I let you out, you're going to show up?
Yes, sir.
You promise?
I do.
Your Honor, just to note,
Go ahead.
I do see that she didn't qualify because she is transient, doesn't have a stable residence. I do also see 3 failures to appear, though it does seem like the last one was 2 years ago, but just to make the court aware if it wasn't already.
Yeah. Is there any amount of bond that you can make?
At this time, being homeless, no, all my money is going towards hotels and everything for me and my kids.
Who's got your kids now?
The father.
Okay, is that the victim?
Yes.
Okay, so he's got the kids now? Okay. How are you gonna, what are you gonna do if I release you today? What are you gonna do? Because you can't contact him, how are you gonna work out the kids?
My mom, I spoke to the DCF caseworker, and she was supposed to be letting my mom know where they were to go get them and everything like that. So that's already been worked out. All I need to do is just go get us a hotel room.
All right, I'm gonna ROR you.
Thank you, Your Honor.
If you don't show up, then you're just gonna get arrested again, and I guarantee you next time, they'll keep you in jail and you won't see your kids. If you need to deal with your kids, you can't have any contact with their father. That means no calls, no nothing. You gotta find some other way to do it. All right?
Yes, sir.
All right. Your name, sir?
Jeffrey McAlpine.
Okay, sir, you have been arrested on 2 charges, one of possession of cannabis under 20 grams, and the other is battery as an act of domestic violence. I've read the arrest affidavit. I do find probable cause. Would you like to have the public defender appointed to represent you?
Yes, sir.
All right. The public defender will be appointed. You're presently being held on no bond on both charges. Counsel, would you like to be heard?
Yes, Your Honor. Mr. McAlpine is McAlpine. The accused is entitled to reasonable pretrial release conditions. He has 0 criminal history, 0 FTAs, nothing in Florida or out of state, so he has to be released on his own recognizance.
State?
State would request PTR with appropriate conditions for the DV battery charge, Your Honor.
Let's see. This says he doesn't qualify for PTR.
I just saw
I think it's because he didn't provide an address. Correct me if I'm wrong. It just says right here, unable to verify address. So that's, I'm asking if that's why he didn't qualify.
Is that why he didn't qualify, just that?
He did not provide any contact information, so we couldn't verify.
I can give you my house address, but I don't have a phone number, though.
Is that the
Yeah,
same
the
house that
emergency
you were
contacts.
sharing with the victim?
Yes, but my belongings are now in my friend's house in Claremont, so I don't need to have any connection with her at all.
So he
Okay.
could go live in Claremont. He could give that address.
So
And still make it here.
do you have the address in Claremont?
Not right offhand, but I can give it to you guys as soon as I
Can you get it
figure out.
before you're released?
No, because I don't. My friend's number is in my phone, and it broke before I got arrested. So
Okay. Well, I'm going to set a reasonable bond because you don't really even know where you're going just yet. So I'm going to set a bond. Suggestion is to amount.
State would request $1,000.
$1,000 from this request from the state.
We request a $500 bond on the battery and a $100 bond or an ROR on possession of cannabis.
All right, I'm going to set the bond on the possession of cannabis. That'll be ROR, but on the battery, that'll be $1,000 bond.
So the funds in there.
And no, the special provision of no contact. You don't have to have any contact with the victim of any kind.
Right.
Not through you, not through your mom, not through your best friend, not through anybody else. The only person that can contact the victim on your behalf is your attorney.
Okay.
Even if your mother on her own wants to call the victim, tell her not to, because
Okay.
it's only going to get you in trouble.
Okay.
All right?
Yes, sir.
All right. All right. Sir, what is your name?
Patrick Kent Moore.
Okay, and you are charged with the crime of battery as an act of domestic violence. I do find probable cause to believe that that was committed. This involved, and this is a question, well, first off, would you like the public defender appointed to represent you even temporarily?
You mean at this hearing?
At this hearing?
Yes, sir.
Okay.
That's fine.
Then we'll appoint the public defender just for the purposes of this hearing.
Yes, sir.
To represent you. You're presently being held on no bond. Does the council want to be heard on that?
Yes, Your Honor, it looks like there's a victim present, so I'll
very good.
inquire once.
Go right ahead.
Hello, can you guys hear me?
Yes.
Okay. My name is Henry Moore. That's my dad over there. And honestly, the situation that happened was at the boathouse, and it escalated to something that it even shouldn't have. And all it was just I said something rude to my mom, and he tried to reprimand me and like just popped me on the mouth, and it hit me in the nose. And I had 2 bone marrow transplants at the age of 7, and so I bleed really easy, and my nose just started gushing blood. And so that man puts food on our table. Like, he's the reason that we have a house and a lake house, and he's a major provider for our family. So, and I still love him to death, and I would like contact, and I do not want to press any charges whatsoever. And
y'all are from Virginia?
Yes, sir.
You down here on vacation?
Yes, sir.
All right. I'm going to state. You want to be heard?
The state was just going to request a reasonable monetary bond to be set, and then just a no hostile contact order, though they reside in Virginia.
Based on what I read, I think ROR is fine. I don't think a small bond is going to make a difference. And the only restriction, sir, is you're not to have a hostile contact with victim. Just if somebody has to reprimand him, let your wife do it.
Yes, sir.
At least until this is resolved. Are you planning on going back to Virginia?
Oh, yes, sir.
Okay, you will need to return.
Yes,
So
absolutely.
if these charges are filed, you will need to return to Florida to address them.
Absolutely.
But if not, then we'll find out. Anyway, thank you, sir. Thank you, young man.
Yes, sir. Thank you.
ROR, no hostile contact provision. All right. Okay. Sir, step up. What's your name?
Wilcon Rose.
All right, Mr. Rose, you have been charged with the crime of battery as an act of domestic violence. I've examined the affidavit, and I do find probable cause for that crime. Would you like to have the public defender appointed to represent you?
Yes, sir.
All right. I have your affidavit in front of me, and the court will appoint the public defender to represent you. At presently, you are held on no bond.
There's a victim present, so I'll let her testify and then make argument.
Certainly. Would you please tell us your name?
Yes, I'm Stephanie Lero.
Okay. And were you the victim in this case?
Yes, sir.
All right. What would you like to tell us?
I just don't want any contact. I don't want to press any charges. I just want this to, I don't want any contact, that's all.
Well, let me tell you this fact. I can order him to have no contact with you now. But if you don't pursue the charges and the charges are dropped, then the court has no jurisdiction over him. You can, however, go down to the Orange County Courthouse and request what's called a domestic violence injunction. That is a vehicle that will allow the court to order him not to have contact with you long term,
Okay.
even if the criminal case is not pursued. Do you understand
Okay.
that?
I will look into that, yes, sir.
Okay, you need to look into that because you can go down there on Monday morning and get it filed and have it done expeditiously. In the meantime, on the issue, any testimony you want to take?
No, I've heard everything you need to hear. I just want to be heard on argument once
Okay.
the court's ready.
Anything else you want to tell me?
No, thank you.
Okay, thank you very much. Go ahead.
Your Honor, he qualifies for pretrial release according to the face sheet that I have in front of me. I don't know if it's changed. On this face sheet, it says he only has 1 misdemeanor conviction and no failure to appear, so we'd ask that he be released on pretrial release.
All right. State?
Yes, Your Honor, he does qualify. The only history I see is a duelist and no failures to appear. The state asks that there be a no contact order and that they maintain separate residences.
All right.
If not already.
We would also request a one-time return with law enforcement so he could retrieve his belongings.
Okay. So, are you going to be able to stay away?
Yes, sir.
She's going to go and get an injunction Monday,
Okay.
and that'll survive the criminal case. Understand?
Yes.
All right.
Your Honor.
So I'm going to release you on pretrial release. The condition is you're to have absolutely no contact with the victim whatsoever. It means you can't call. It means you can't write. It means you can't reach out in social media. It means you can't have your mama call her. You can't have your friends call her. You can't have anybody call her to try to get her to drop the charges. Looks like she may do that already, but nobody calls her.
Yes, sir.
All right? If you do, it's a violation of this, and you get put back in jail, and you could also be punished for contempt of court. All right. Anything else?
No, Your Honor.
All right. That's done.
Thank you, Your Honor.
Okay. What's this? Okay, could you please tell me your name, sir?
Oh, yes, Anderson.
Okay, that's this one. All right, sir, you have been arrested on the charges of burglary of a conveyance, criminal mischief, and resisting an officer without violence. I've examined the arrest affidavit and I find probable cause as to all three. Would you like to have the public defender appointed to represent you?
Yes, sir.
All right, I see, I have your financial affidavit, and you do qualify, so I will appoint the public defender to represent you. At this point, your bonds are set at $3,500 for burglary of a conveyance, $150 for criminal mischief, and resisting an officer with violence. The bond is $100. Does either counsel want to be heard on any issue?
We ask that you reduce the bond on the first count. He only has 2 misdemeanor convictions and 0 failures to appear.
State would have no objection to a reduction. State would request at least $1,500.
All right, I'll reduce it to $1,500 on count 1, but the other amounts will remain the same.
Thank you.
And that concludes proceedings for that case. All right, what's your name, sir?
Mason Banks.
All right, Mr. Banks, you have been arrested for the offense of grand theft, third degree of a motor vehicle. In this matter, I've examined the arrest affidavit. Does anyone want to be heard on probable cause?
No, Your Honor, unless you have a suicide.
Well, I do.
Okay.
I believe the crux of the arrest affidavit is, let's see, make sure I'm thinking of the right person here, is that this defendant was a passenger in a vehicle that turned out to be stolen. If I'm not mistaken, the case law indicates that being a passenger in a stolen vehicle is not grand theft. It may be trespassing a conveyance if the person knows it's stolen, but it does not constitute grand theft, unless I'm mistaken.
No, I actually, now that I think about it, I've heard that before. I think you are correct.
So, go ahead.
Your Honor, I believe you are correct. The state would request that you find probable cause for a trespassing conveyance.
I do find probable cause for, well, let me look at this again.
Otherwise, the state would ask for a 24-hour reset to see if there's more information.
Right, just a second. Well, I'm going to find probable cause for trespass in a conveyance based on the facts in the existing affidavit. The defendant is presently on PTR on a trespass in a conveyance in 2019 MM 3725.
May I be heard on that?
You may.
No information's been filed in that case yet.
State can give me any more information about that case?
That's correct. Nothing has been formally filed. The state would request, though, that bond be revoked, or,
What was that? That was obviously an arrest. When did that occur?
it occurred on the 2nd of May, is when
2nd.
he was arrested.
When was he released on bond?
On the 3rd.
The 3rd of May?
Yes, the very next day.
And this is the 24th of May. Well, pardon me?
I was just gonna say his 30th day's coming up anyway. In about a week.
That's true. Well, I'm going to revoke PTR on that case, and I'm going to set a monetary bond of $500 on the older case, and I'm going to set the bond on the trespass count in the new case at $500 also.
Thank you.
Okay.
Yep. Got that down here.
All right, sir, what is your name?
Louis Busso, the third.
Okay. Okay. Mr. Busso, you have been arrested on the charge of possession of cocaine. I have examined the arrest affidavit, and I do find probable cause for that offense. Would you like to have the public defender appointed to represent you?
Yes, Your Honor.
And let me see, don't have an affidavit here. Hold on, let me see, is it on the back? There it is. All right, so I have your affidavit of insolvency, and you do appear to qualify, so the public defender will be appointed to represent you in that case. You are presently being held on $1,000 bond on that case. You also are out on bond on another case, 2019 CF 5319, I don't know if it's 5319 or 53191.
I have 5319 AO.
Okay, there's an extraneous mark there. Okay.
If I could be heard, no information's been filed in that case yet. It's been well over 33 days. That arrest was 4/13/2019.
Can you give me any more information on why these cases
I
are?
don't see any charges filed. I have an arrest date for April 22nd.
Oh, I'm sorry, I misread. I see offense date. It's still over the 30th day, but I see offense date of 4/13, and then there was a warrant arrest. That's why the warrant arrest is a little bit later.
Well, that was a $10,000 bond that he set. Is that correct? All right, I'm not gonna do anything with the new case since the state has yet to file it. And I'm gonna stay the bond as $1,000 on the new case.
Okay.
All right? All right, sir, what's your name?
John Patrick Calderon.
Mr. Calderon.
Yes, sir.
You have been arrested on, I'm sorry? Oh, did I do that again? I'm sorry.
Did we miss a count or something?
Yeah,
no
we missed
motor
it. We missed a
vehicle
charge here. Sorry.
Oh, is it no motor vehicle
Yeah,
registration?
yeah. Sorry about that. Thank
That's
you.
okay.
Well, we can go ahead with Mr. Calderon, and while Mr. Busso's coming back in. Sir, you've been charged with possession of amphetamine.
Yes, sir.
I've looked at the arrest affidavit. I do find probable cause. Your bond is presently set at $1,500.
Yeah.
Would you like to have the public defender appointed to represent you?
Yes, please.
All right. I have your affidavit in front of me, and I do find you qualify, so I appoint the public defender. Any counsel want to be heard?
Your Honor, he qualifies for pretrial release according to this face sheet. I don't know if anything's changed since then, but the face sheet I have says he does qualify, so we'd ask for him to be released on pretrial release.
All right. Yes.
State would also just ask that drug screening be a condition.
Then the court will order PTR with drug screening, whatever that's called.
Thank you.
Drug conditions, or whatever you want to call
Because
it.
they'll revoke it, and then you'll be no bond.
I gotta go to work Tuesday.
All right. Thank you. You're welcome. Yeah, you can go. Mr. Calderon, yeah, we're done. Oh, Mr. Busso, I'm sorry, we forgot a charge. There's another case, you were charged with driving without a motor vehicle registration. I do find probable cause for that as well. And your bond in that case is set at $500, which will be stayed at $500. Okay, would you like the public defender appointed in that case too?
Yes, sir.
All right, public defender will be appointed in that case as well. All right. All right. What's your name, sir?
Joseph Churko.
Mr. Churko, you are, have been arrested on charges of, this is just one, right? Let me just make sure I don't, see, that's one. I see there are two. There are, this is two, right? Yeah. There are two cases that you've been arrested on. Both have similar charges. In the first case, the charges are burglary of a structure, grand theft third degree between $300 and $5,000, and criminal mischief over 200 and less than 1,000. I've read the affidavit and I do find probable cause as to both charges. Would you like to have the public defender appointed to represent you?
Yes, sir.
All right, I've looked at your your financial affidavit and I do find that you qualify. Public defender will be appointed. Your bond on count 1 is $3,500, count 2 is $150, and count 3 is $100. Anything else from either counsel on that case?
No, Your Honor.
So the bonds will be stayed on that case. The other case you have, which is 7507, you're charged with burglary of a structure, grand theft, well, same charges actually. Yeah. Make sure this is not a repetition. Nope. Separate case. Grand theft and criminal mischief, under $1,000. Your bonds on those cases are $3,500 on count 1, $150 on count 2, and $150 on count 3. Would you like to have the public defender appointed to represent you?
Yes.
All right, we'll appoint the public defender to represent you, and the bonds will be stayed as stated. Anything else from anybody?
No. Are there the other case numbers, or is this?
I think it's just the, oh, you want the two case numbers?
No, it's okay. I just want to make sure, like, are we done with him?
Yes, we're done.
Okay.
I believe we're done with him as far as I can tell.
Okay.
Okay. Can you tell me your name, sir?
Jarvis Brandon Clayton.
Hi, Mr. Clayton. You've been charged with the crime of possession of cocaine. I have looked at the arrest affidavit and I do find probable cause. Would you like to have the public defender appointed to represent you?
Yes, sir.
All right, I've looked at your indigency affidavit and I do find that you qualify, so the public defender will be appointed. Your bond on the possession of cocaine case is $100. Anything from either counsel?
No, Your Honor.
All right, bond will be stayed at $1,000.
Wait, did you say 1,000 or 100?
1,000.
Okay, for some reason I heard it in 100. Never mind. Go ahead. That's fine.
All right, sir, what is your name?
Oscar Corona Hernandez.
All right, sir, you have been charged with fraud, a false statement in order to obtain a driver's license, and perjury in an official proceeding. I have examined the arrest affidavit. Does counsel want to be heard on the issue of whether the facts involve an official proceeding?
Yeah, I don't think it's perjury because it's not like, I mean, speaking from personal experience, I've never sworn to tell the truth, the whole truth, and nothing but the truth at the DMV. Maybe I've signed something not realizing it, but I don't think it's qualifies as an official proceeding. I mean, I think the first count makes sense, but the second count, I don't think qualifies for the facts in the affidavit.
Counsel is.
Your Honor, the state would just argue that it is a state government agency, so.
Well, what I'm going to do is I'm going to find probable cause on count 1, but I don't find probable cause on count 2. simply because I know that there's a certain limited definition of what an official proceeding is, and I don't know that applying for a driver's license meets that definition. So what the court's going to do is to ROR the defendant as to count 2. Count 1, sir, your bond is $1,000. Does either counsel want to be heard on anything else?
Yes, Your Honor. Mr. Corona Hernandez has 0 criminal history in Florida or out. According to this face sheet, he doesn't even have any arrests. So I'd ask for him to be RR'd on both counts, given his lack of criminal history.
Go ahead.
Because we're unable to verify any community ties, the state would ask that the bond be stayed.
Yeah, I think in a circumstance where I don't really have any information here as to any ties to the community, and he was using a false identity. So at this point, the bond will be stayed.
At $1,000?
At $1,000, yes. All right, what is your name, ma'am?
Katrina Crocker.
Okay, and you are charged with possession of methamphetamine, MDMA. I have read the charging affidavit. I do find probable cause for that charge. Would you like to have the public defender appointed to represent you?
Yes. Yesterday, I was talking to somebody in pretrial services, and he said that he was going to put in order for me to have pretrial and the bonds be taken off.
And do what now?
He said he was putting in an order for me to go to pretrial release it, and that he would take the bonds off of me, seeing as though I had just got out of jail like 7 days ago.
Well, the first question is, do you want the public defender to represent you in
Yeah.
this case and beyond?
Yeah.
Okay, then I'll appoint a public defender to represent you. Your bond is set at $1,000, and you do not qualify according to this for PTR. From the face sheet I have, does either counsel want to be heard on the subject of bond?
I mean, if PTR says she doesn't, why, if I could ask PTR, why does she not qualify? Is it because their address wasn't verified, or? I'm asking.
Well, it says she has 4 failures to appear. The last one was 4/18 of 2019.
I don't know if that bars you from PTR. No,
She did not provide any contact information.
I provided to him yesterday my contact information, which is 4532, the pretrial release people that I talked to before I came upstairs. I talked to a man, and I provided him with an address, a phone number, which I've stayed at for like 8-9 months already. And he said that he would get put in order to the address so that he would take the bonds off me and pretrial release me. That way I can, come.
I'm sorry if he told you that, but we can recommend you, but we can't take bonds off of you.
Okay. Based on the failures to appear, the last being very recently, I'm not going to put you on PTR. I'm just going to leave the bond at $1,000. So the bond will be stayed.
Hang on. What do you want to say?
I'm just standing to stretch, no other reason.
No, it's okay. On the second count, we just asked that she be RR'd. It's an open container.
Oh. Oh, I don't have a second count on, is there a separate? Oh, wait a minute, here we go. Oh, yeah, ROR on the open container.
We can't argue after he's already ruled.
And there's probable cause on that one?
Yes, probable cause on that one. Sorry.
So you argued with it. We can ask for a bond motion later, but we can't.
Yeah. You can talk to the lawyer later on, but we need to get moving on, so.
Bond court is a free service, but it takes several hours of my time every day. Less than 10% of Bond court viewers hit the like button, and less than 1% leave a comment. If you want Bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.